This writ petition has been filed as writ petition number 10550 of 2023, Lordship. The petitioner is the constable, Lady Constable of the Security Force, Central Security Force, Lordship. The relieving date has been fixed 29, that is tomorrow, Lordship. Already all criteria all has been done, and the please Lordship will be pleased to fix the second half so that the matter can be heard unless the matter will be infructuous, Lordship.
Why will it be infructuous? Please tell me.
Lordship, relieving date, that has been discussed.
She has been transferred.
Lordship,
she has been transferred.
She is the constable. She is the lady.
She has been transferred.
Transferred is Lordship, transferred. The Lordship transferred, and the relieving date has been fixed. And
all right, nothing will happen. It will appear on Monday.
It has been fixed.
That is all right. Nothing.
At 2 p.m. I have some matter before your Lordships. But one matter is continuing. My junior will be there. Kindly, my lord.
What time?
Well, may I be allowed to mention this matter? This is a group 9, a group 7 service matter. But due to lack of determination, His Lordship, the Honorable Justice Subhagos, was pleased to release the matter due to lack of determination. Let this matter be appear in the list. Group 7, new motion,
Group
service.
7. I do not have Justice Ghosh's determination.
Group 7, service.
Group 6 is service.
Oh, sorry, group 6, service.
Yes.
Group 6, service.
Lordship,
Transport.
may I be permitted to mention one matter, Lordship?
Group 6.
Lordship, it is a new writ petition, Lordship. It was previously taken up by His Lordship Honorable Justice Arindam Mukherjee. Lordship, he had directed for affidavit in opposition. It has been filed just yesterday, Lordship. I'm praying for inclusion in the monthly list.
No, I am not including hearing matters at the moment. Please look at the list. There is a note. I am not including hearing matters in the list at the moment. Lordship.
May I have your Lordships kindly to mention one matter which is not in your Lordships list. My lord, with notice to the other side, I am mentioning it. My lord, kindly have a look at the order, my lord.
Yes.
My lord, no AO has been filed yet, my lord.
But I'll keep it as to be mentioned.
My lord, deeply obliged.
Next week, I'll keep it as to be mentioned.
My lord, will it be Lordship's pleasure to take it up to be mentioned at 2 p.m., my lord?
No, to be mentioned in the morning.
My lord, one thing is this, my lord. My Ladne Junior comes from, my lord, 25 kilometers from Asansol, my lord. So he reaches Howrah station at about 11 aki. That is the difficulty only. If your Lordship can, deeply obliged.
He will have to come.
My lord, on the I stay in Calcutta, my lord, I have rushed it. If he fails, then I will step in, my lord.
When you want it, you tell me. You fix a date. You tell me next week when you want it.
Now, as your Lordship, as your
No, you tell me which is convenient for you. You tell me.
Copy.
Let the file come. Let the file come. It will appear.
My lord, any day from Monday to Friday, any day subject to law. Deeply obliged. Monday next week. Monday, next Monday, my lord.
Next month is holiday.
Oh, any day subject to law.
All right, let the file come.
Yeah, at the earliest any day. Deeply.
We mention item number 1. For the petitioner, Lordship, kindly I'm praying for Lordship's attention to the order dated 17 February 23. Yes. Lordship, the third paragraph, leave as paid for is granted to add the Indian Bank and the officers concerned as party respondents. I went to the department and the department requested me to, Lordship, to pray for correction. Instead of that, it is with Lordship the substitute.
I cannot understand.
Lordship,
Please speak on the microphone.
Lordship has directed to add the Lordship Indian Bank and the officers as a respondent because we have implemented Allahabad Bank. Subsequently, it has been Indian Bank. So, Lordship, the department has requested me, Lordship, as my application is, where instead of add, it will be substituted, Lordship. Only to such extent, Lordship, I'm praying for correction.
Leave as prayed for by Mr. Mukherjee to substitute Indian Bank in place instead of Allahabad Bank is allowed. Full stop. leave is given to make necessary changes in the cost title. To such extent, the order dated February 17, 2023 is clarified. Full stop. Server copy.
So let the matter appear under the heading lawsuit, hearing lawsuit is a affidavits already have been exchanged. It's a compassionate appointment.
Item number 2.
My lord, in this matter, my lord, respondent number 2, Provident Fund of India, where Mrs. Aparna Banerjee is appearing.
Miss
My lord,
Aparna Banerjee's legs in another court.
my lord, that's why I'm praying for short pass over, my lord. But she has not.
She's praying for a Passover on the
I am
ground
praying
of
for the
Aparna
petitioner,
Banerjee.
your lordship. I am praying on behalf of the petitioner.
Come back next Friday.
Next
Your lordship.
Friday.
My lord, only
No,
pass.
বলেছিলেন না।
Respondent number 2.
ঠিক আছে না, তো
Whenever is the next working Friday?
Okay. Oblige, my lord.
Item number 3.
Your lordship, 3 to 7, I'm praying for not this week only. I'm for
Whenever
the
is the next
petitioner.
working Friday?
Your lordship. Respondent number 3, I'm appearing for respondent number 3.
I'm just making it not to demand.
Applications, item number 89.
My lord, 89.
6 আছে 1 to 7 বললো item number 6.
1 to 7, she said.
257. Mine is
Sir.
lordship, that provident fund matter. Item number 6.
6.
On 25th, your lordship was kind enough. That matter. And lordship, may I pray before your lordship to file a supplementary affidavit only that notice has been issued by the provident fund for recovery. May I? Not this. This. I have soft copy on my learned friend. If your lordship kindly take the trouble to consider 24/3/2023's order, lordship. Everything has been quoted here.
Yes, your minutes are here.
Yes, ma'am. The copy is- Keep it.
Minutes of 21st October 2022.
Still on that day, madam, no minutes has been recorded.
That is the
And on 4/7, on the basis of the 4/7 order, my lord, on the basis of the 4/7/2022, my lord,
Please speak
Right.
on the microphone.
when the representative of the company stated that they have nothing to say, and that is why they have closed the agreement, they closed the hearing, my lord. On that basis, order has been passed on
No.
10th of
No,
21st
because,
October
this is-
2022.
This is relevant. that's why
Yes.
directed you to produce the meeting minutes of
But-
21st of October.
25, hearing has concluded on 4/7/2022, my lord. Kindly, my lord. Kindly come to my lord's page 225. Kindly come to my
Page?
lord's page 225. 225, my lord. On that basis, hearing has been completed, my lord, and order has been passed on 21st October 2022.
And that recording is lordship, that recording is wrong. Your lordship will find from 226. Middle para. On going through the above order, has the lordship.
My lord, yes.
Then 7A.
Then
2
we will
was
come
not.
to page 205. Page 205, my lord. The church. Page 205, my lord.
The order, where is the report of 4th July 2022?
No, my lord, I will come to page 205. Then it will clear, my lord. 205.
I have seen, where is the order of daily report of 4th July 2022?
Nothing is there.
That is the order. On that day, they have submitted that they have kindly come to page 205, my lord.
Nothing is there, lordship.
Page 205.
Yes.
That's correct.
Okay, so from the last paragraph, how does it appear that it is concluded?
We have made
From
the
4th
representation.
July 20, this is the
Petitioner
one I was.
company, petitioner company will authorize 2 persons as their representative to attend the hearing.
From this 4th July 2022's order, it doesn't appear that the hearing was concluded. What is the meaning of paragraph number 3?
They have deputed 2 as representative of the company, my lord. We hereby authorize Rahul Dasan and Sujit Kumar Shah to appear before the good sale and to plead, argue and submit papers and documents to defend on behalf of the company and to do all and every act and things as requested. Then come to 225, my lord. Then come to 225. Same day hearing was done. They have stated they have nothing to say. They have received the EO's report. On June 21st, EO's report they have received. After that, they said they have nothing to say. That is on 4th July 2022. And final order passed on, my lord, 21st October 2022. From 4th July to 21st October 2022, they have not sent any communication to the department through email or through letter, my lord. After passing the order,
Where
was
is
passed
the
on.
order?
After passing.
Where is the order?
It starts from 220
Page 220.
and the last page is 223. 21st October 2022. They have passed the order. And
prolonged hearing, my lord, all along they have appeared.
And on the last occasion, I have placed before your lordship the page 228 that this gentleman has got the habit to make wrong recording. Lordship, kindly
One second,
Why
Mr. Big.
they, what,
How was this served? The document at page 225, how was this served and when was this served on the petitioner?
we received 224 lordship. We received the same on 9th November 2022. 224 lordship. Kindly take that.
page. Lordship, the fourth, sir.
No, fourth. Final order.
No, I'm not talking about the final order.
Final.
This
I'm
order.
not- I'm not talking about, I am talking about the document at page 225.
After receiving this, we we have downloaded the last day's recording, and thereafter, Lordship, we made the submission on 4th November 2022, where we have said that on 3rd we got the we have downloaded from your website the aforesaid order. However, we have not yet received any order by post or through mail. 226, Lordship. Once we have downloaded, then we have seen that this has been there. Then on the next day we have given it. 4th November 2022. And in paragraph 34, page writ application page 21, we have stated, your petitioners state that in the first week of November 2022, it has come to know from the office of the respondent number 1 that an order has been passed by the said respondent under section 7A of the Act. Then we downloaded it. 21, page 21. And Lordship, these gentlemen, Mr. Shailesh Kumar, is in habit of recording wrong statement that your Lordship will find from 228 and 229.
And why they have not stated after 4th July? After 4th July, why they have not stated?
The thing is that how have you,
After 4th July, my lord,
how have you intimated your order of 4th July to them?
It has
You please show that to me. You are saying that from 4th July to October, they haven't taken any steps. That you have to show.
on that day they have appeared, my lord. 4th July they have appeared.
Yes,
4th July
but
they have-
your recording, they are not admitting your recording. So now you please show how you have served that order to them.
They have to see. In the bottom, my lord.
কি রেখেছেন দাদা?
4th July ওই করে। Hearing has been concluded, my lord, on their submission. They stated that they have nothing to say. On
You
that
please
point, my
look
lord,
into this, Mr. De.
on that
You
point, my
look
lord,
at the
hearing has been
signatures at the
concluded.
bottom. Look in-
On that point, my lord, hearing has been concluded on 4th July and final order passed on 21st October 2022. In between
The
this
day you
period,
take necessary instructions in the
Yes,
matter.
yes, because I have not.
Yes, please, because the copy that you have attached
Yes, it is
it
the
does
server.
not contain any signature. Please take
Absolutely.
necessary instructions in the matter. Ashu,
একটা কপি নিচ্ছে।
please give me a copy.
my lord,
Do you have a copy?
no extra copy will I will give you.
No, I'll retain with the records. You do not have any copy.
আপনার কাছে এক্সট্রা কপি আছে?
No extra copy, my lord. I'll give to my lord.
Please give it to him. It will be Xeroxed.
তো কিছু নেই কিছু।
A copy of the written instructions as submitted by Mr.
কিছু
Rakshit,
নেই কিছু।
appearing on behalf of the
কারণ
Regional
categorical
Provident
statement
Fund
করেছি,
Commission.
হয়নি।
hyphen Roman 2 is retained with the records. Full stop. He submits that. It is clearly recorded in the order dated July 4, 2022, diary number 124/2021, that the authorized representatives appearing on behalf of the company not have any further submission to make in view of the inquiry officer's deposition. Full stop. In that view of the matter, the Hearing was concluded and the judgment was reserved for order. Full stop. Next, after submitting that they have nothing further to submit in the matter, the petitioner company cannot now urge that there was a breach of principles of natural justice since they were not permitted. Now, the representatives of the petitioner company were not permitted to cross-examine the inquiry officer. Full stop. Mr. De, learned counsel appearing on behalf of the petitioner submits that the inquiry officer was in a habit of recording wrongly and the order dated July 4, 2022 was not received by the petitioner prior to the same being downloaded from the website after receipt of the final order dated October 21, 2022 on November 9, 2022. Full stop. Next. From the written instructions submitted before this court today, this court finds that there are two signatures at the bottom of the order dated July 4, 2022 with the endorsement, inverted commas, or with the received, inverted commas closed. Received, inverted commas closed, full stop. In such view of the matter, Mr. De is permitted to take necessary instructions in the said matter, full stop. Let the matter appear for further consideration under the same heading. Motion holder on May 12, 2022, 2023. Server call.
MDP. Inquiry রিপোর্টটা পেয়েছিল সেটার জন্য রিসিভ লিখেছে।
Item number 89.
89, who is for the petitioner?
For the 89.
This is for a modification of an order passed under section 17B. And the factory where the workman was working had closed in the meantime. License surrendered, not the distribution company has disconnected the electric supply insofar as the manufacturing process is concerned, but whether section 17B can at all be proceeded with after this, or the company can suffer the interim order insofar as 17B is concerned. All workmen, settled their dues. He was earlier terminated from service. That's carrying on. That proceeding is going on.
Who is appearing for the respondent?
The evidence of closure, your lordship will be pleased to find at page 14.
Ms. Pandey is appearing.
No.
For respondent number 4. You are for respondent number 3.
Wardman.
Ms. Pandey was here.
It's item 89.
89.
89.
5179.
5197.
Mrs. Delta.
5197.
5197.
The first order is at page 12. 7th of May 2014, the 17B was allowed.
You are for the employer.
I'm for them.
You are saying that the establishment has closed down.
Yes, the factory where the workman was working has been closed down. Please have a look at page 13. That's the operative portion of the 17B order.
Page 13 of the
Application of CAN 7 of 2021. The major objection at that stage was that he was working in some other establishment, namely NM Dyeing, to show that he was gainfully employed elsewhere. But then the court was not satisfied with the evidence produced, and then in page 13, it has been held that in view of the aforesaid, the application under section 17B is required to be allowed. Accordingly, the petitioner shall be entitled to interim relief in terms of 17B on and from September 2007 till the writ petition is disposed of. The arrears payment shall be made within 4 weeks from the date, and all subsequent payments shall be made on or before 7th of each succeeding month. The application is accordingly allowed and disposed of. Original record produced by ESI in relation to NM Dyeing is returned to the learned counsel representing the ESI counsel. Since thereafter, the company's factory has closed down, which your lordship will be pleased to find from page 14. Notice of partial closure of Delta Fabrics Limited, situated at Ganganagar, so and so. Kindly turns over to page 15, the penultimate paragraph on that page. In view of the above facts and circumstances, we are unable to find any way of running this factory anymore. As a result, it has been decided to close the factory on 31st of May 20 with effect of partial closure from 1/6/2020. Therefore, the services of the workmen will be redundant and they will be terminated from service of the company by way of retrenchment on 31st of May 2020. The workmen on the payroll of the company shall be entitled to retrenchment benefits as specified under section 25F, payment of gratuity under section 4 of the Payment of Gratuity Act, and other dues, if any. This is to be noted that actual work continued up to 23rd of March 2020, whereas payment of wages has been made up to 31st of March 2020. From 31st March 2020, the factory remained non-operational till date. Hence, the period from 1/4/20 have been treated on the principle of no work, no pay. However, without any prejudice of law and as a gesture of goodwill, gratuity and retrenchment compensation will be paid up to the date of retrenchment, that is 31st of May 2020. Individuals' communications of retrenchment along with calculation of full and final dues, a copy of this closure notice, and the checks will be sent to the individual workers. But this was issued on 25th of May 2020. Now, we were unable to remove the materials, the finished goods from the factory premises, for which we had to approach the writ court, and the court allowed us to remove the finished goods, which your lordship will be pleased to find at page 22. Or the last paragraph of page 21. And accordingly, WPA 10077 of 2020 is disposed of by directing the respondent number 2 to arrange for a police picket to be posted at the factory premises of the petitioner for the period required for the petitioner to remove the goods, which the petitioner is liable to deliver to its customers. It is made clear that this order and observations made therein shall not prejudice the rights and contentions of the parties in other pending litigations or legal actions between the parties to the present writ court. It is expected that the respondent number 2 shall intimate the necessary costs for deployment of a police picket to the petitioner at the earliest, latest within a week from the date of communication of this order. This was
a different issue.
the issue of closure has been carried out has been challenged in an industrial dispute which is pending consideration before the industrial tribunal. That's a separate issue altogether. There were whosoever was on the rules of the company as on the date of closure, that is 7th of May 2014, had been retrenched. On the date of May 2020 had been retrenched, and where the factory has been closed down.
Let Ms. Pandey also come. Ashnu. Mr. Mujumdar, learned counsel, appearing on behalf of the petitioner. Employer submits that since the factory has been closed and not closed by a closure notice dated May 25, 2020. The issue with regard to whether payment is required to be made to the employee stroke respondent number 3 under section 17B of the Industrial Disputes Act needs to be addressed. Full stop. Next. Let the matter appear for further consideration on May 12, 2023. Under the same heading motion. You are for respondent number 3.
Yes, madam.
Please give your appearance.
May I file the affidavit of service in terms of the earlier order?
It is the application doctor. Under the same heading application. Affidavit of service filed in court today be retained with the records. It about the recan 7, it is scan 7. Scan 7 of 2023, Mona had to do. This is a cancer. 2021.
Yes.
Can of 22.
Yes, of 2021.
90.
I will need, at long last, after my lord's order, they sat with me yesterday. I'll need another 7-8 days for the written instruction.
My lord had given them 4 weeks.
I know, I am not, next
Mr.
week is the
Chatterjee,
Friday.
We are trying to solve the issue.
Next Friday is a holiday.
Well,
I am keeping it on 21st.
My lord will indicate that that will be perhaps the last chance.
Chatterjee.
no, yeah,
This-
it's,
We are trying to work it out.
for your advantage, but otherwise, well, this is.
It has to be resolved.
Fixed deposit.
You are waiting since long.
We are waiting. Our existence is at stake now.
Waiting since
that
long.
did
Let
not-
us see if we can solve it. Let us see. Otherwise, there will be an order of court.
But
Let us see.
it will be 14 days from now. Next Friday after.
Next Friday
The
is
holiday.
not a working day.
12th
So
March.
the Friday thereafter.
I'm grateful. 12th, borrowing.
Try to resolve it.
Item number 91.
No, this is challenging an industrial award which had been passed against my client without a notice. Now,
Can 1, can 2. Can 2 of 2023.
my lord, this is an application for amendment of.
Under section 17B of the Industrial Dispute Act.
No,
One
that's
second.
not,
Is it can 1 you are facing or can 2?
not can 2 is my application for amendment of the cause title, since not in the meantime, the company had merged with, I mean amalgamated with another company. Can 2 of 2023 is an application for amendment.
And you are appearing in
I am-
support of can?
I am the respondent workman.
You are the respondent worker?
Respondent number 4.
Respondent number. You have a can application?
I have filed an application under section 17 of the Industrial Dispute Act.
All right.
My application should be heard first before the hearing of the writ
Which
application.
is your application? Please tell me.
But I have filed an application can 1.
Is, that is, old number is can 5764 of 2016.
Really can 1. देखना. In your application, the coordinate bench has already passed an order.
No, my lord, in my application, there is no order. In
All
his
right, please
application,
take
well,
me to the
kindly see
coordinate
the order.
bench's order.
Kindly see. There is no whisper of my application.
Please take me to the coordinate bench's order. I think before that order, your application was filed.
My
Before
application
that
was
bench
not
of your
half.
order.
The 27th of June 2016.
Please take me to the coordinate bench's order, sir.
But kindly see the order, my lord.
Yes. The order is dated.
My lord. There is.
Mr. Mojumdar, this has to be heard out.
But kindly take your lordship's.
Because I will be
order.
very frank, my view is not matching with the coordinate bench's order. I have to be very frank. I have indicated that to Mr. Shorkar also because on the last occasion he appeared. But the coordinate bench's order is there. And as far as I remember, the CAN application was filed before the coordinate bench's order. I think that it was filed prior. But so to the mind of this court, that application was taken into consideration and on balance of convenience, this order has been passed. I do not want to make any comments with regard to that, but this has to be heard out.
It's a very short point. Not on the other hand, not my
Because
learned
there
friend's
is
client.
statutory provision.
Correct. Now, not he has waited for till his prospective date of retirement almost now. He's 57 probably now.
Yes, but if any injustice has been meted out to him, I have
Correct.
to
Now,
take
not
that into
for
consideration.
7 years he had sat tight over the matter, not moved the application. Now, not if your lordship's conscience has to be satisfied also that during this interregnum period he has not gainfully employed himself otherwise.
It's a different issue, but there was a statutory provision
He did not move.
to the mind of this court that should have been taken into
Correct.
account.
Now, not he has not moved the application for a period of almost 7 years now. Today, if your lordship's conscience has to be satisfied, he has to be called for another. He has to file another affidavit saying what he has been doing for another 7 years down the line. He has to disclose materials for the purpose. He says that he was drawing 53,000 rupees per month. Now he's 57 years of age.
I do not know what he was doing, but
No, I'm not what he was doing.
he was doing, not doing. The question is whether he was gainfully employed or
Correct.
not.
Now, I'm not for that
Now, if you
purpose.
challenge the fact that he was gainfully employed. You show me that he was gainfully
No,
employed.
we used an opposition. There was an application filed in 2016. He's pressing this application in 2023.
I understand, but whatever is his statutory dues, he has to be given.
Yes, of course. Now, not if he has to kindly also visualize this situation after a period of 7 years, we may not be in a position to reconcile the fact which was existing in 2016. So he has to, in all fairness, he should come up with a fresh affidavit saying what he has been doing for all these 7 years with disclosure of materials.
That is all right. He will say that on affidavit, but whatever his statutory dues are as an employer, you have to pay.
No, not under section 17, the preconditions have to be fulfilled. One of the preconditions is the court has to be satisfied that during this period he has not been gainfully employed or he had not been earning adequate remuneration. That's the language used in the proviso to the section.
I have to industrial disputes.
In this regard, I have also filed the affidavit. Lady, he has to prove his liability.
I am saying he has to prove. I am not saying you file another affidavit, he will file a reply to that.
My lord, once I have, it is his liability. I have to show the judgment. Once I have filed the affidavit, that he should file the affidavit that I have been working.
হেঁটে চলে কোথায় চলে যাচ্ছে
ঠিক আছে সেই জানি provided that, but I am not on the first part of the definition. Provided that where it is proved to the satisfaction of the High Court or the Supreme Court that such workman had been employed and had been receiving adequate remuneration during any such period.
Yes, but you will have to prove it. If you are urging that point, you will have to prove it.
No,
If
but I
you
am
are
saying
not
that
a-
all that I am submitting is not since 2017 when the court passed the interim order, he chose not to move the application. After 7 years, he is now trying to re-agitate an issue.
Sometimes business of the court doesn't permit.
But I would have mentioned, not had
But that application is there. That
Correct.
application
No,
is
that
there
application
and
also
I
needs to be
have
disposed of.
advocate that.
Yes, that also has to be disposed of. Now, not in the context of that application, but he should, in all fairness, file an affidavit saying what he has been doing for these 7 years with disclosure of materials of his bank accounts, income tax returns, whatever was there. Because not this satisfaction of the court not has to be fulfilled. But it's quite abnormal that a workman who is the beneficiary of an award will sit tight for a period of 7 years without praying for not the interim relief application being moved.
Maybe he didn't have the money.
Not the application is to get the money.
He did not have the money to
Not the
move
application.
the application
the app-
or whatever it is. I cannot go into that. But I have to be satisfied that he was not gainfully
Yes, not
employed.
for that, not of what he has been doing for these 7 years. Kindly directs him then in that event. Not, I'll show to your lordship, not from a very cursory glance of the award. Not he got this award against me, although he was an employee of a different company. Got the notice served on a different company.
But
But,
over here, I do not want to get into what order the coordinate bench has passed because section 17B should have been considered.
But I only want to show to your lordship that that will be the end of the matter. Your lordship's order on 31st of March, that this should be heard out on this, on a particular day. Because they have not moved the application. Not the notice was in respect of a different company and I suffered the award.
So now today in Can 2, what do you want?
But Can 2 is only to amend the cause title in the sense that not the company has now merged with a different company, so the cause title needs to be amended to bring a subsequent development into the court's notice.
Ashu.
May I submit one thing?
Yes, you file another affidavit. I'll consider your application.
Well, I
Understand.
have already kindly see the judgment. But Division President of this court, well, paragraph 9.
I am not on the issue of your merit.
No, merit, no, I concept in regard to affidavit.
Motion কি বলছেন বুঝতে পারছি না।
My learned friend says that I have to file the affidavit after 7 years. Kindly paragraph 29, Manu. Kindly see.
You please look at the second line.
Yes.
Over here, it has been recorded that the counsel representing the employer with petitioner had not disputed the factum
Yes.
that the applicants were unemployed during the pendency of the proceeding.
Yes.
In this case, they had not disputed that factum.
Kindly see the.
And over here, there is a single bench, coordinate bench's order staring at your face, where the balance of convenience has been decided in their favor. Please,
But-
you have to take,
With regards to
you have to
state
let the
award.
court pass.
Kindly
its
the
order.
bottom portion, Manu.
You have to let the court pass its order. Over here, the factum that you are working is not under challenge. And over here, his entire argument is that why have you not challenged it for 7 years? That means you are gainfully employed. Ashu. এটাকে Can 2টা করুন of 2023. This is an application for amendment of the cause title of the writ petition by bringing in the necessary parties on record. Full stop. Such amendment is allowed and parties are given leave to make necessary amendment to the cause title. Full stop. Furthermore, leave is given to file a supplementary affidavit to the writ petition to bring the subsequent developments on record. Full stop. Next, Can 1 of Can 1 টা কত? হ্যাঁ কত?
কোনটা? Can 1টা?
হ্যাঁ
2016।
Can 1 of 2016. Full stop. This is an application by the employee stroke respondent number 4 for payment of his dues under section 17 capital B for payment of his wages under section 17-B of the Industrial Disputes Act, 1947. Full stop. by an order dated June 27, 2016. The ordinate bench of this honorable court was pleased to pass an interim order whereby it was held that the balance of convenience stroke inconvenience lay in favor of the petitioner stroke employer, full stop. The application being CAN 1 of 2016 was not considered in the said order, full stop. Next. Under section 17B of the 1947 Act, the workman has to satisfy this court that he is not gainfully employed or receiving adequate remuneration during the period the employer prefers, during the period the proceedings preferred by the employer against an award passed by the Industrial Disputes Tribunal is under challenge before this court. Full stop. Next. Since a considerable time has elapsed between filing of CAN 1 of 2016 and the date of this order, the respondent number 4 is directed to file a supplementary affidavit explaining his financial position during this period. Full stop. Next. An opposition is permitted to be filed to such supplementary affidavit filed by the employee, when a workman. Full stop. Next. The entitlement of the workman in respect of the provision of section 17B of the 1947 Act will be adjudicated thereafter. Full stop. Next. Let such supplementary affidavit be filed by May 12, 2023. Full stop. Opposition, if any thereto by May 19, 2023. Full stop. Let the matter appear for further consideration under the same heading application on June 9, 2023. ওটাকে bold এ করে দেবেন। Serve a copy.
Madam, may I take back the judgment?
You want this
Yes.
judgment? All right.
The affidavit of service.
আপনার বইটা না এই যে You're for the petitioner? You're for the petitioner?
Yeah.
Kindly come this. Kindly come this side.
There are two applications. pending. One is for substitution, another is for early hearing. Early hearing, I don't want to press now, but substitution, it will be allowed. Court,
Please show me which is the application for substitution. What is the application number?
application number 6051. This is for substitution. Of petition number 2. Service করেছি।
Please give me an affidavit of service.
My lord, I have served.
That's all right. You have to show me. Please give it to me.
I have served.
No. Where is your affidavit of service? Give me your service.
Then I'll do accordingly.
This is a 2019 application and affidavit of service has not yet been
Affidavit
affirmed.
service is not required.
I do not want to get into that. Whether or not you have affirmed it, you please tell me.
But I have served.
Ninth of June.
কি বলছে?
Item number 93.
কি বললো?
9 June.
হ্যাঁ?
Your Lordship, I beg to appear on behalf of petitioner.
Yes,
Petitioner.
yes.
My lord, Mrs. Alam is, Chandri Alam is appearing on behalf of the Union of India. Madam, she is engaged in LAPITA.
Just a minute. Let me
Your
hear to what
Lordship,
the application
Your
is
Lordship.
about.
Your Lordship, one Triptimoy Sarkar, Your Lordship, was a constable CRPF, and unfortunately he died in 2007. His wife tried to obtain succession certificate. It was contested by the mother-in-law of the petitioner, Your Lordship, and learned additional District Judge Purulia, Your Lordship, was pleased to direct that the death benefits will be divided into 50% share in both the petitioner and the mother-in-law. Your Lordship, after that, some death benefits, Your Lordship, has been disbursed, but family pension and some 1-2 benefits, Your Lordship, it has not been disbursed. And they are now saying that according to the Rule 54 of CSS pension rules, Your Lordship, the family pension can only be given to the widow, Your Lordship. After that, Your Lordship, we have made one RTI and we have got to know, Your Lordship, that unfortunately the mother-in-law has now died in the 2022. Your Lordship, now there is no impediment to, Your Lordship, release the entire
Yes, Mrs. Alam was supposed to take
Lordship.
instructions.
Lordship.
She was supposed to take necessary instructions.
Lordship, Your Lordship has directed.
I'm making it just not today.
Not today.
Lordship.
Not today. I'm just
Lordship,
making
great.
it not today. You come back on the next working Friday.
Lordship, grateful. Okay, Lordship, grateful, Lordship. Grateful, Lordship.
94.
I am appearing on behalf of the petitioner, my lord. This is application for restoration bill. The matter dismissed for
What is your ground?
the
And
matter
of 2022.
2022. The matter was dismissed. Can 2 and can 3. The one on the application for restoration and second on the application for section condonation of delay. Can number 3 is the restoration application. And two is the coordination of delay.
Can two section 5 page. Ashu.
Yes.
Recan 2 of 2022, full stop. This is an application for condonation of delay. In filing, the restoration application being Can 3 of 2022, full stop. Next, peruse the grounds, full stop. Next, such grounds are found to be sufficient, full stop. Next. In such view of the matter, Can 2 of 2022 is allowed and Can 3 of 2022 is taken up for consideration. Full stop. That will be Can 3 of 2022. This is an application for restoration of WPA 12612 of 2022 by recalling an order dated March 11, 2022, passed by a coordinate bench of this honorable court. Full stop. Next, peruse the grounds. Full stop. Next. Such grounds are found to be sufficient. Full stop. In such view of the matter, the order dated March 11, 2022 is recalled and WPA 12612 of 2018 is restored to its original file and number. এগুলোকে সব bold করে দেবেন, ঠিক আছে? WPA নাম্বারটা restored টা। Serve a copy.
This is my affidavit of service.
প্রথমে affidavit of service, I signed the report today.
Yes.
Item on 95.
Dismiss. Can to dismiss.
Thank you. Yeah.
96.
96, my lord, I am appearing for the petitioner, my lord. There is two applications, one application for restoration, my lord.
Lordship, actually, it is very sad to inform you that learned counsel for the respondents, Mr. M.M. Burma, has passed away on last 26th April, Lordship. So I am praying for an accommodation.
But this is a restoration application. His junior is not there. No one is.
No.
Then you have to come back.
Lordship, kindly maybe in monthly list of June.
June.
Because Lordship.
I'm keeping it on 12th of May.
Yes.
Come back on the 12th of May, 2 weeks.
Okay, obliged.
Obliged, my lord.
97.
My lord, this is an application for restoration. My lord. Two restoration applications are there, my lord. Can 2 is restoration of Can 1 and Can 1 is restoration of writ petition, my lord. Two restoration applications. Here is the affidavit of service, my lord.
Can 1 আর 2 বলছে, এটা 2 তো এবারে 1 টা কোথায়? না, Can 1 টাও dismissed for default হয়েছে।
Can 2.
The Can 1 আছে তো। Can 1 of 2023.
can one and restoration. Malad, both the applications have been served, Malad.
Re-can 1 of 2023. Now, aage korun re-can 2 of 2023. This is an application for restoration of an application for restoration being can 1 of 2023. Filed for restoration of WPA number 16297 of 2019. Next. Peruse the grounds. Such grounds are found to be sufficient. Full stop. In such view of the matter, can 2 of 2023 is allowed. Allowed can bold করে দেব এবারে re can 1 of 2023. This is an application for restoration for recalling of an order passed by this court on April 5, 2023 and restoration of WPA number 16297 of 2019. Full stop. Peruse the grounds. Full stop. Such grounds are found to be sufficient. Full stop. In the circumstances, comma, the order dated April 4, 2023 is recalled and WPA 16297 of 2019 is restored to its original filer now. WPA ta restored ta bolde kore debe server copy আর এটাতে ওইটা লিখে দেবেন affidavit of service filed in court কেন কেউ appear করে না
It would be a lush.
98.
98, my lord, I'm for the petitioner, my lord. But I'm praying for not today, my lord. The service upon the respondent has not been effected yet.
all right not today
Obliged, my lord.
99.
Lord, I appear on behalf of the petitioner.
Your lordship, I'm for the High Court administration being led by.
you are for the petitioner
I'm to.
Kindly
lordship.
come.
Yes, I'm sorry.
Yes.
Your lordship, I'm praying for short pass over, your lordship.
Sorry.
Your lordship, I'm led by Mr. Joydeep Kaur, your lordship, senior advocate. He's engaged on
Next
the.
day.
Milord, only one difficulty I am facing that I should. Milord, only thing, Milord, I found my an accommodation of Mr. Kaur. I cannot sell. I cannot make any submission. But Milord, one of the employees of this court, of this honorable court, Milord, will be retiring. Milord, on 30th of April 2023. And Milord, this is the matter which your lordship will recall. This is 30th of April 2023.
Yes, but even if he retires, his benefits he will get.
Indicate.
Ultimately, if it is allowed, then he will get the benefits.
No, I do not say anything with
After
regard to
retirement
that, but
also.
Milord, a stand may be taken that he has retired, therefore his case, Milord, do not stand in the footing of the other persons. That is the reason I am expressing my agony. Otherwise, I have
That I
nothing
will
to
make
say.
it clear. That I will make it clear in the order.
Kindly,
Because
kindly do.
even if it is a retired employee, they will be getting the same benefits. There will
I know, but I know the views of my lords, but even then, Milord, I say, Milord, I have nothing to say.
And in this case, I think once an accommodation was sought for you on your behalf.
On my person, I was admitted to nursing home, Milord, and I tender my unqualified apology for that. Your lordship
This matter and
had
accommodation. was
granted
also,
me,
if I
and
remember
Mr.
correctly,
On
it was
Mr.
sought
Kaur,
for
I
you.
have nothing to say. I cannot make because in the corridor every day, Milord, we are looking at each other. We are making, Milord, many comments. Therefore, very well, Milord. I say, Milord.
Now, what is the situation? It has been
Situation is
deferred.
situation,
The
yes, it has
promotional-
been deferred. Now, my lord, what I will be making one prayer before my lords, a representation has been made. This particular,
But Mr. Bhattacharya, what I'm trying to say is that
Yes, my
if
lord.
it has been deferred and then he retires, what can be done?
no, I say, my lord, that this matter, because of pendency of the matter was not proceeded with. Because of pendency of the matter, other persons,
He
my lord, I am told
retires before the promotion is being
a
granted.
list
How-
has been prepared.
Maybe,
A list has been prepared,
maybe, but
but
if he retires,
excluding,
if he retires before the promotion is granted to people, what can be done?
no, my lord, your lordship will kindly consider, my lord.
This is pending since 2020. It is not so that it is just pending from 2023.
No, I am not on that, my lord. I say, my lord, that this writ petition is pending.
I do not think that it was also deferred because of pendency, because it was supposed, the promotional examination was supposed to be held on January 6, 2023.
Yes, and
And the
there,
writ petition has been filed in 2020. So I really do not think that because of the pendency of the writ petition also this.
no,
process
I
has
am
been-
not, I am not saying anything. I am only indicating that if kindly takes into consideration, kindly keep this in mind.
No,
that-
but if I am saying, I am also expressing my mind to you, if he
Yes, my
retires
lord.
and after that, if the promotional.
Your
process
lordship
is
may
carried
kindly
on-
consider, my lord, that this notice, which was issued, one notice was issued on 25th of January 2023. Then another notice, my lord, was issued. Before that, my lord, one notice,
6 January 2023.
6 January 2023, thereafter by postponing the matter. I am grateful to my lords.
So, but if the process is not completed before his
The
retirement.
process,
what can be
if
done?
the process has not been completed, I cannot make a submission. But if the process has been done, excluding the,
That is a different
that's
thing.
that's the
That-
only,
that is a-
that's my
yes,
only argument.
that-
Yes, yes,
that
yes.
In accordance.
That,
with law,
if they have not
pendencies
taken
are-
any step, if they have,
That that will be granted.
that's what I am making a prayer. Nothing more than that.
Mr. Kaur is here.
দাদা আমি কিন্তু আগেই বলে রাখছি আপনার সম্বন্ধে বলেছি আপনার দুজনে কিন্তু বারান্দার মধ্যে দেখা হলে আমি কখনো কিছু বলতে পারবো না মিস্টার করে রেখেছি আমার এত ক্ষমতা নেই
We were adjourning it because of you.
I'm really grateful, Lord. I'm grateful to my learned friend. I believe he was giving me compliments. So I thank him for that.
He is saying that the difficulty is one person will be retiring.
I think.
On 30th of
আমি
April.
দিচ্ছি আপনাকে। এই লোকটা
কি করা যায় রে?
আমি আপনার উপর ছেড়ে দিচ্ছি। আমি কোনো কথা বলতে পারবো না।
পরীক্ষা দিয়েছে কি?
কে দিয়েছে?
না না পরীক্ষা দিয়েছে কি এরা পরীক্ষায় বসে
Is the examination over?
No.
In January, it was postponed.
I believe, Lord, the examinations are over. The results have also been published.
Published.
Yes, that's my instruction today.
Please, do you
Yes,
have a copy of the instructions with you?
Ache?
Yes, Miller, results have been published.
Results have been published. Then
Lord, I am not,
you have an instruction.
I have not appeared in the examination
Did respond.
because I made a submission before my lords
So, but
that there is a changing of the criteria.
what is the instruction of the added respondent? Have you received the?
We are, Millard, already, Millard, our palette has already been Millard, exhausted when we have been promoted earlier on. Millard, they are challenging that.
No, no,
They are
but
challenging that.
you have to produce the. Motion.
Instruction from the plan.
But kindly, Lord, pass it over for 10-15 minutes.
I will not be able to pass it over.
I see.
Mr.
Lord,
Then next working Friday.
next Friday, kindly keep it, Lord. We'll and call for a report, Lord, in the form of an affidavit. I think, Lord, that should clear the position.
Next working Friday. I
Next working. ठीक है।
said. Mr. Kaur, learned senior counsel, appears for High Court Administration and submits that the promotional examination for filling up the vacant posts of, within inverted commas, daftari and record arrangers, inverted commas এর মধ্যে, have already been concluded and the results of the examination have also been published.
Milord, so kindly, Milord, take into consideration my submission on instructions I am submitting that the departmental examination has been done. But so far the posts are concerned, the number of the candidates who had taken out the present application or writ petition, that has not been filled up. This is my instruction by the persons, Milord, who are working in the High Court department.
Next, Mr. Bhattacharya, learned senior advocate, appearing on behalf of the petitioners, submit that even though the examination has been conducted, the vacancies have not been filled up from the petitioners who have instituted the present writ petition being WPA 438 of 2022. Full stop. Next, this court feels that justice will be subserved by calling for a report on affidavit from the Registrar General, the stroke, the respondent number 1, on the issue whether the promotional list has been published and vacancies to the aforesaid posts have been filled up. Full stop. The marks obtained by the incumbents in the promotional examination has to be also disclosed in the said report on affidavit.
And so far as my candidates are concerned, Milord, the persons who have come here.
Let the matter appear
Yes.
for further
Yeah, but the
consideration on
appointment will
May
be made in as a matter of fact.
12, 2023
12.
bolded under the same heading application bolded. Yes,
Milord, I have
recorded your submission. I have to see whether
Yes,
they
yes,
have
yes.
in the promotional exercise where they stand, what has happened,
Very well. Very
how
well.
much they have scored.
They came to court on the ground that without examination, they should be
That
promoted.
I remember.
So therefore, your lordship said that you
Yeah, I
participate.
do have to participate. That was my view.
That
And now the results will be brought by way of an affidavit.
yes.
So now I'll see how they are
Yes, the
placed.
entire picture will be before.
How are they placed and whether some posts are kept vacant,
And
whether
kindly
they have been, despite getting necessary marks, whether they have not been
No, of
assigned
course,
or designated to those posts. That I'll just.
of course, not. We'll
And
place-
also, Milord, kindly examine the change criteria during the pendency of a proceeding, whether change criteria can be made to apply for promotion. Because when I filed the writ petition, my rights stood crystallized on the basis of certain rules and regulations. There are no rules and regulations so far as the post of Daptari and the record keeper or arranger is concerned. Now, Milord, they introduce some criteria. Now that criteria which they introduce, whether that will be.
Maybe there were no, we will see.
Yes,
No
kindly
votes for
take
that
into
year's
consideration.
promotional
Yes.
exercise, we will see that.
Yes.
Item 100.
My lord,
Lord,
I
for
appear
the
for the respondent numbers 3 to 8. My
For the petitioner, my lord, the
The
opposition
opposition.
was affirmed beyond time and I was served yesterday only, my lord. I am paying time to file my reply.
lord, I
What is the
That
application
is,
about?
My lord, the application is about for early hearing and passing necessary order.
Early hearing.
And also for
the
passing necessary order, my lord.
may I indicate. My lord, may I submit my affidavit in opposition, my lord?
My lord, I need to file my
My lord,
reply,
in
my
the
lord, I'm
draft
paying
of this
time.
application, they want to get the writ petition heard finally. If your lordship kindly takes up the writ
This is
petition.
for early hearing. That is what she
No,
said.
my lord, kindly see the
My
prayer.
lord, early hearing and also for necessary order, my lord, not only early
The
hearing.
prayer.
Anyway, I'll dispose of this application. I'm not passing any order on this application, Ashu. This is your affidavit in opposition to
Yes.
the main writ petition?
No, my
Or
lord,
you
you
can?
can, my lord, to the application.
Look,
Can.
Can,
Yes,
my
my lord.
There was an order by your lordship, my lord.
My lord, I need to time to file reply, my lord.
Wait. An affidavit in opposition filed to Can 1 of 2023 is retained with the records, full stop. It is submitted by Ms. Odhikari, learned counsel appearing on behalf of the petitioner, that the said opposition is handed over to her in court today. Full stop.
No, my lord, I sent
Said
it
she
by,
got-
no, she said, my lord, my clerk rang her up, my lord. She refused to accept, my lord, because it's
Mr.
beyond
Das,
time.
learned counsel
So
appearing
it
on
was
behalf
sent by
of
post.
ECL submits that
Sent by
said
post.
opposition was not accepted by the learned counsel appearing on behalf of the writ petitioner. Full stop.
It was sent by post to them.
My lord, it was supposed to be affirmed on 10th April. It was
Maybe, my
affirmed
lord.
on 24th.
It was late, my lord, but she refused.
Time as paid for to file an affidavit in reply to the said opposition is granted. Full stop. Let such reply be filed by May 17, 2023, full stop. Let the matter appear for further consideration under the same heading application on June 9, 2023. Look at
Great.
folder. Server copy.
Good, my lord.
Can 1 হলো
I'm appearing for the respondent applicant. We have taken out this application really to wriggle out of the present situation. I tell you, lordships, during the pandemic period, this is in relation to South Bengal State Transport Corporation. During the pandemic situation, because of the certain employees rendering exemplary service to the state during that period, board of directors of the authorities took a resolution in deviation of the statutory rules that those persons should be giving promotion. That promotion was given, but immediately thereafter, considering the provisions of statutory rules that promotion can only be given on seniority cum merit, that decision was withdrawn. Now petitioners came before this honorable court. This honorable court stayed that withdrawal order of promotion. We also preferred an appeal against that because it is against the statutory rules.
the petitioners, who were the petitioners who approached before this court?
The petitioners who rendered the exemplary service,
They came before this
they
court.
came. And they got an interim order against the withdrawal, decision of withdrawal.
Yes.
Now we preferred an appeal, but we could not succeed in against the interim order that should be decided on affidavit. Now the difficulty we are facing, some of those employees, the petitioners, have retired in the meantime. But we cannot fix up, the pay, because whether they should be fixed in the promotional or if they
For the appeal court.
appeal,
I will not be able to do anything in this matter.
appeal is not, this has to be decided before your lordships.
I am sorry. I do not agree with that. You please go.
Appeal
to
is
the appeal
disposed
court.
of.
Appeal is disposed of.
Yes, this is against the interim order, my lord. That cannot be decided on merit. Even if we go, your lordship, that's an interim order. This is a limited appeal. So writ petition has to be decided on merit, my lord. Affidavits are complete. Now I cannot disburse, my lord, the sum of the retired employees, the pension, my lord, the retirement benefits. That's the predicament of the corporation, as well as of the petitioners, of course. Some of them have retired, we have discharged, disbursed the provident fund. But the gratuity, all other retirement benefits, we cannot, unless the pay fixation is made, my lord. That's the only problem, your lordships. That's why we have taken out this application. Not kindly take it up.
No, because there is already an order, interim order of the single bench. Please take me to the interim order of the
Yes,
single
your
bench,
lordship.
because it has to be done in accordance with that, with an undertaking that they will,
Yes.
with an undertaking that they will give it back if they do not succeed.
Well,
in the
that's
litigation.
an interim order, but kindly visualize the situation after retirement. How could I realize that? We will not,
Because you are granting pensionary benefits every day, every month.
against the pension, my lord, there cannot be. And pension, this is not, I'm told, my lord, this is not a pensionary service. Only gratuity, my lord, CPF, contributor, no, GPF, no CPF, your losses. So, but very short point, your losses, kindly. Whether the rule will prevail or the decision of the board of directors against the rule will prevail, considering the exemplary service rendered by them. That's the point involved, your lordships. Really, this is an application with request to your lordships to hear out the matter in view of the Malad situation. And that was also observed by the.
Now you have to give the benefits because this court cannot take up this matter in preference to others. You have to give them the benefits and you have to with an undertaking.
Well, I have to pay, fix the pay, my lord.
Yes, or on the basis of the.
Well, kindly, my lord, decide on that, your lordships, so that we can proceed.
Well, at page 26 of the application, my lord, kindly come, my lord.
Yes.
This is the order of the division bench.
Yes.
The honorable division bench is of the opinion, my lord, that second paragraph. At the same time, this court is of the view that since the promotional benefits already granted by the order such and such which have been given effect to are required to be continued until the writ petition is finally heard.
That's all.
So, my lord,
So I have given that benefit.
they can
It's
fix
post-retirement benefit.
my lord, the retirement benefit, my lord, as a from your lordship with an undertaking, my lord, we are ready to give that.
Yes, you give an undertaking.
Yes, we are ready.
That it will, whatever it is, it will
Well,
abide by
then your
the
lordships,
decision of the.
well, kindly give them collateral security. My lord, I tell your lordship, this is not pensionary service. How can I require, my lord? Suppose your lordships, my lord, somebody dies tomorrow. How do I realize it?
File an affidavit. You file an affidavit stating how you are going to fulfill your undertaking. You file an affidavit to the scan.
May I suggest one thing, subject to
Yes.
correction, my lord? Item number 118 of my lord's list, my lord, today. This is the same matter where an employee retired from service taking the benefit of this order. My lord, as fallen from your lordship, I can file affidavit on that application, my lord. It is better, my lord, I think.
That is a different thing. You file an affidavit stating whether you are willing to give an undertaking.
Lord.
And if you give an undertaking, how do you propose to, whether it is by way of an indemnity bond or whatever it is, how do you propose to fulfill that undertaking in the event the writ petition is not decided in your favor?
Lord.
Please do that,
I'll-
and then I'll decide this application first.
Lord.
Ash.
But, my lord, of course, this is at the cost of repetition. To some extent, that will create complications. If your loss is a point
I am
sort.
so sorry. I will have to go by what I feel. Just because you want me to take up this repetition
No,
before
that's not
everything.
as a prayer before your loss.
I cannot help it, Mr.
Well, in a,
Shanmugam.
because of this peculiar situation, your losses kindly. Otherwise,
Equally, it is because of you. You have given them and you have, maybe you have not done wrongly. You have given them the benefits and today you come and tell the court it is a peculiar situation. What can the court do?
the court has
You
taken.
have done it.
Well, that's a decision only, my lord.
Decision. And it's not that this court is of the view that you have done wrongly.
No, that's a prima facie, my lord.
Prima
At the
facie
interim
view.
stage, prima facie view your losses. Now, the statutory rules whether the board of directors can go against,
Or not done.
that's your losses. So, my lord, statutory form will not, my lord, will go, will be always above the board of directors. So that would, my lord, in the entire situation, your losses. That
The subject matter of this application.
my lord, may I take your losses,
Yes,
leave?
yes. Is for providing of fixation of pay, stroke, retirement dues of some of the writ petitioners in WPA 5377 of 2021 and for early hearing of the said writ petition. Full stop. In the nature of promotion, additional service benefits, etc. to the employees and their spouses. Full stop. Such was ratified by a resolution dated June 16, 2020. Full stop. Next. Thereafter, it was found that it transpired that promotion could only be granted on seniority cum merit basis and there may have been a violation of the statutory rules in granting promotion to the writ petitioners. Full stop. Therefore, the promotional benefits granted to the writ petitioners were withdrawn by a communication dated February 1, 2021. Full stop. Next. Challenging the aforesaid order of cancellation, the present writ petition was filed. Full stop. The Honorable Coordinate Bench, by an order dated March 3, 2021, was of the view that due to the special, commendable and outstanding service rendered by a batch of employees, they definitely deserved special award. Full stop. The employees who did not render such service could not be put at the same footing as the employees who rendered the same. Full stop. Therefore, comma, at the interim stage, the
service. Or even at the time of mentioning, my lord, I had served notice to the bank had received the notices. My lord, date of dismissal 10th July 22, my lord. My lord, I filed this application, my lord, in, my lord, November 22. There's been a delay of 104 days, my lord. So I have also taken out an application for condonation of delay. My lord, the main cause is, my lord, the advocate, who was the earlier advocate on record for the petitioner, he's mainly practicing in Jalpaiguri now. So was not present when the matter was called.
He could have prayed for a virtual hearing.
I'm not sure, my lord, what they did. And I don't think, my lord, at that point.
Is it a change brief?
Yeah, this is my change brief, my lord. I am now with you.
এগুলো না প্রবীর বাবুকে সকালে দেওয়া আছে একটা কন্ডোনেশন একটা রেস্টোরেশন দুটো পরপর আছে আর অর্ডার ডেট অফ দ্য অর্ডার ইজ
10 July 20.
June 10, 2022, not July, 10th June.
বললাম
আজকে সকালেও একটা দিয়েছে। All right, allowed.
My lord, I know my lord is taking up applications only. But my lord, in the writ petition, my lord, there is no scope of an interim order. My lord, be pleased to give directions for affidavits.
No, not today.
Very good. My lord, if the writ petition could come up in my lord's list there.
I do not usually do that, madam. Once I restore it, then you have to mention an affidavit of
Very good,
service
ma'am.
to be kept on record.
Grateful, my lord.
Lord, this matter, Lord, this application for Lord, the expeditious disposal of the writ petitioner. Lord, the writ petitioner was served. There was a direction for exchange of writ that has not been filed. Below the Lord disciplinary action, Lord, that is reducing my the pay scale during my service period, and that was given effect even Lord after my superannuation. So, Lord, I have been superannuated. Lord, there is a Lord the defect so far as the disciplinary proceeding is concerned, because the ME2 he proceeded, the inquiry officer proceeded on the basis of the ME2. That is not at all admissible in evidence. Lord, I will demonstrate this fact. Lord, Lord, the affidavit in opposition has not been filed. My learned friend is appearing today. Lord, I have given
Admittedly, my lord, there has been a delay, your lordship. After filing of the writ petition, the bank was supposed, there were talks going on of a different view if it could be taken.
Sorry, madam.
Well, after filing of the writ petition, my lord, the bank, their talks were going on in between the bank, that different view could be taken up, but at last, my lord, it did not mature, my lord. Admittedly, there is some delay, your lordship. I am ready with the affidavit in opposition, your lordship. If your lordship so directs, your lordship, I can file it today and serve it to my learned friend as well.
Ashwin. You will file a reply.
I am Lord, I have to file the reply.
Affidavit in opposition filed in WPA 18746 of 2021 is retained with the records. Full stop. The petitioner is granted leave to file an affidavit in reply by May 18, 2023. Full stop. Parties will be at liberty to mention the matter for hearing after expiry of the time stipulated for filing of affidavit in reply. For hearing the bolded, serve a copy.
Sir, may I be prepared?
Can 1, accordingly, can 1 of 2023 bolded is disposed of bolded.
Sir, may I be permitted
grateful,
to submit
Lord.
one thing, Lord, after kindly fix the date of hearing.
I am sorry that I cannot.
I'm deeply obliged to you.
Grateful to Lord. Your Lordship, and for the petitioner, Your Lordship, there are two applications, one for the restoration, can 1 for the restoration, and can 2 for the condonation of delay.
What are the grounds?
Your Lordship, on the day the matter was dismissed for default, and the advocate on record, I was the advocate on record, and because of medical condition, I could not appear, Your Lordship. I have all the medical records with me. I was on the way, but I had,
And then why is the delay of 132 days?
Your Lordship, I was not in a condition to take it further. I beg your pardon, Your Lordship, for that.
You have to tell me the reason why were you not in a condition?
Your Lordship, I suffer from a chronic disease. It's called Meniere's disease. It's a vertigo, incurable. So because of that, I was not in a position to move further.
ঠিক আছে. All right, allowed. We একই condonation of delay and order dated. July 8, 2022.
Much obliged, Your Lordship.
My lord, item 105, my lord, I appear for the petitioner. My lord, Mr. Jointo Mitro is, my lord, leading me. But he's, my lord, keeping unwell. My lord, he's not been able to come to court today. My lord, there's some urgency, my lord. May I only move, my lord, in case required, I'll come back. My lord, the writ petition, my lord, my lord, was appointed by, my lord, the Respondent Institute in, my lord, 1990. My conditions of service say, my lord, that I'm entitled to GPF. My lord, however, my lord, I find that I was being continued in CPF. I complained to them, their board meeting, my lord, they accept I'm entitled to GPF.
Yes.
Thereafter, my lord, I've been pursuing my claim, my lord. Ultimately, I filed my writ petition. Initially, my lord, I had said that, my lord, there's no scope for interim order as such. My lord, affidavits were exchanged, my lord, and I was given liberty to, my lord, mention after completion of affidavits. However, my lord, the list is, my lord, saying that the hearing matters, my lord, I cannot mention. In the interregnum, my lord, I am to retire, my lord, in August. My lord, and for that, my lord, to complete the formalities for that, my lord, they have given me, my lord, the notice that I have to fill up, which, my lord, they will be pursuing now since I am about to retire. In the notice also, my lord, they are continuing to erroneously reflect me in, my lord, CPF category. Although, my lord, my lord, terms of appointment say, my lord, it is GPF, and their board meeting, my lord, they accept it's GPF. My lord, only for this, my lord, the apprehension really, my lord, is that the matter is ready for final hearing, my lord. There is a chance it may not be heard, my lord, before I retire in August. But only to protect the list, my lord, some sort of an, my lord, interim protection I was praying, my lord. Otherwise, later, my lord, the defense will be raised, my lord. There is no such defense as such. Then, my lord, the defense will be raised, my lord, that it may have become, my lord, infructuous with time.
Lord, the affidavits are exchanged, as my learned friend has said. So, my lord, if your lordship kindly keeps it for
Please
hearing.
tell me, is there any real dispute in the matter?
Yes, yes. Lord, the dispute is this, my lord. Initially, he opted for CPF. That is continuing. Thereafter, my lord.
He opted.
Yes. Thereafter, my
He's
lord.
saying that your board meeting reflects
no,
that he's
no, my lord.
entitled to GPF.
Subsequently, my lord, after he came into the faculty, my lord, he is claiming that I should go to GPF because earlier he was not in faculty. He was in other post. So, my lord, so if he chooses to go for GPF, now my lord, his past service would go because he opted in the past service. He opted for GPF. So there is a long dispute.
CPF.
CPF, right? So my lord, there is a long dispute which cannot be decided without hearing the writ petition. And another thing that I want to point out before your lordship, regarding pension of Indian Institute of Management, the central government is the authority. All pensionary matters, CPF, GPF, central government has directed that everything would be done by them. In the writ petition, we have taken point in the affidavit in opposition. The central government has not been made a party.
My lord, no such direction is, my lord, on record in the opposition subject to correction. And, my lord, they are a statutory body now. My lord, they have their own seal.
The leave
Yes.
can be given to them. That is
My lord,
not an
as far as, my lord, his point, my lord, that I have
that
opted.
anyway, that
I'll
is
explain.
not really
So, my lord,
important.
simple explanation.
The question is whether or not he himself has exercised the option to continue with the.
Lord, as I told you, lordship, lord, in the earlier cadre, where when he was not in the faculty, which he belongs to now. Now, my lord, in that cadre, earlier cadre, he was in CPF, not in GPF, as per his option. Now, my lord, subsequently, when he came into the faculty, he wanted to opt for GPF. That was not accepted by the board. That is the whole dispute. So, my lord, your lordship kindly keeps it for hearing, final hearing, subject to your lordship's
That's
convenience.
Perhaps, my lord, subject to correction.
I don't stand in the way in the matter of expeditious hearing of the writ petition, because affidavits have been exchanged. So, subject to your lordship's kind consideration, lord, and convenience, your lordship kindly fixes a date.
Lordship can fix a date, my lord, only to show, my lord, that the submission is incorrect, my lord. Lordship will only take one page.
This is an application for early hearing. The short issue in the writ petition is that whether the writ petitioner is covered by contributory provident fund within bracket CPF scheme or has opted under the or has opted for pensionary benefits under the general provident fund within bracket GPF scheme. Full stop. It is submitted on behalf of the petitioner that the petitioner is entitled to receive GPF benefits as per the own minutes of the meeting of the respondents stroke the Indian Institute of Management within bracket IIM bracket closed Calcutta. Full stop. Next, Mr. Ray, learned counsel appearing on behalf of IIM submits that such a fact is disputed as the petitioner himself has opted to continue in the CPF scheme. Full stop. Next, let the matter appear for under the heading hearing in the monthly list of July, 2023. Full stop. For hearing on monthly July ke bolde kore din.
I am to, my lord, I am to retire, my lord, in August. In case, my lord, the matter not cut out.
Since this court cannot accommodate matters for early hearing at present, this court is inclined to release WPA 7381 of 2022 from its list. Full stop. Next. With the directions aforesaid, CAN 1 of 2023 bolded is disposed of. Bolded.
Well, let the point of maintainability be kept open.
This is an application, their application. That you take in the main.
If I can come back in July, my lord, even then.
I was trying to accommodate you, but then you
Lord,
tested. I am so sorry. I have released it. Now you take your chance before another court. There is a court specified for taking up only hearing matters. You take your chance. There are many options available to you.
Monthly list of
I'm
July,
so
my lord, please.
I was not permitting hearing matters in any of the cases, but then because he is going to retire, I was considering your case, but it's not possible.
106.
Your Lordship, I am appearing on behalf of the respondents.
Yes. In spite of direction, the respondent officers have chosen not to file the evidence. The application for expeditious hearing of the writ petition. The writ petitioner has been dismissed from service as constable from CRP. The allegation is BGB, and that has not been proved.
The allegation is
BGB.
Right.
So that has not been proved. Your Lordship will be drawn to page 62.
I'm not on the merits today.
Your Lordship, so far as affidavit of opposition is concerned, Your Lordship, it's ready. And we had tried to serve them, but they have refused, Your Lordship. But
No. Without affirmation, they just said.
Is it affirmed now?
Yes, Your Lordship. 30th March. It's affirmed, Your Lordship.
When the
Please hand over a copy here
Yes,
in
Your
court
Lordship.
today.
Your
You need to
Lordship,
file a reply to that. Ashwin,
Your Lordship, please may file the
Yes.
opposition.
Mrs. Roy, learned counsel, appearing on behalf of the respondents, hands over the affidavit in opposition to the writ petition being WPA 7583 of 2022 in court today. Full stop. Such affidavit is retained with the records. Full stop. Let a reply to the said affidavit be filed by May 19, 2023. Full stop. Next, parties will be at liberty to mention the matter for hearing upon expiry of the period stipulated for filing of the affidavit in reply. Full stop. For hearing to bold. Server copy. Key meeting of May 19 for reply. Accordingly, can 1 of 20. Accordingly, can 1 of 2022 is disposed of.
Matter to come.
You have to mention after filing of reply.
Deeply obliged.
107.
My lord, I am appearing on behalf of the respondent number 3, District Judge of Maharashtra. My lord, I don't know what application he has filed. No copy of the application has been.
You do not have a copy of the application. Why? Where is your affidavit of service? 1 second. Let me look at the affidavit of service. You are appearing, Mr. Pal, you are appearing for?
Respondent number 3, District Judge. Perhaps he has served upon my lord, learned government pleader.
Who is appearing? Who is Mr. Bhattacharya? Shajol Kanti Bhattacharya? Who is he appearing for?
Perhaps he is appearing on behalf of the state. Shajol Kanti Bhattacharya. Shajol Kanti Bhattacharya Junior.
Please serve a copy on the district judge.
And my lord, one thing I say my unconditional apology, my lord, though the direction of filing affidavit has been given long ago, my lord, I am playing extension of time to file the same.
By the direction, no affidavit has been filed. And in the meantime, with similar events, employees from Purban Mednipur approached this alone. And while hearing that picture, the learned advocate for the Registrar General submitted that there is no impediment in making payment to the employee. And on the basis of that, I not dispose of that petition. Here is one of this certified copy. And
I don't know.
in other districts also, the benefits have been extended.
Please hand over a copy of the
Yes, sir.
application. Otherwise,
Yes,
it
sir.
will not be, the district judge cannot make any
I have
submission.
supplied my-
You have supplied.
My learned friend has.
And my lord, today, my learned friend appeared for the district judge, not 24 hours. Informed me that he will hand over a copy of the affidavit in opposition to me today.
Not today.
Please give me the
No,
order
well,
passed by this bench.
That's the quoted, my lord, in the CAN application. Select to Mike. And you will turn to page 12 of below the CAN application.
Where is the order? Where is the order? You are relying on?
This is the order
order passed by me in other matters.
অন্য ব্যাটারে
Already annexed. But no order has been annexed. May I make a very small, short submission?
Yes, Mr. Pal, you consider this order. এটা একটু ওনাকে দিন তো। Yes, you make your submissions.
I'm grateful. This is for implementation of the recommendations of Shetty committee. The petitioner says that they are not getting the pay scale which they are entitled to. Now, the similar allegations were there in other districts also. Now, there are after the Shetty commission recommendation, the state government issued 2-3 circulars. The learned district judges are interpreting these circulars in their own humble way. Now, a district judge of a particular district interpreted it in one way. The learned district judge, not 24.
But if the High Court has given.
But High Court stand is clear and
No, not High Court. If this court has given benefits to the employees of one district.
True.
Under the who are attached to the office of one district judge, how can it be not given to the employees attached to other districts?
Absolutely. May I make one submission? After this matter being filed, I was instructed to sit with the court officers, with the officers of the North 24 Parganas District Court.
Yes.
I sat with them. They were saying that certain clarifications are required. What they were trying to say.
Today, why are you saying that? Today he will say that.
May I? It's a short submission. High Court stand is that Shetty committee's recommendation must be implemented. There the High Court stand that is the only stand taken by the High Court in all the matters. Now the clarifications which the learned district judge is possibly asking for were not asked for in the previous matters. I thought this is my duty. I owe this duty to apprise your lordship of
What
this.
the district judge has to say. Because the submission has
My
to come
learned,
from them.
correct. But since I was asked to sit with them, I thought this would be my duty as well. That's why
we will file our affidavit. Kindly extend some time, we'll file. But after passing the order, we have been engaged. That's the difficult.
Direction for filing everything.
Yes,
was
I
given in
appreciate that,
July 2022.
but we have been engaged on a later date.
By Justice
Pal, I think you file your instructions in this matter. You file instructions to this CAN application. No point in unnecessarily keeping it pending. You bring your instructions to the CAN application. Because the prayers are they are asking for the same benefits. By when can you get your instructions? Because since it's pending since quite some time.
Well, then we'll come back.
Because the High Court stands, it's clear that the recommendations have to be implemented.
Shetty committee.
The recommendations of the Shetty
followed.
Commission has to be implemented. So the High Court stand is clear. So now you bring your instructions. When can you come back?
After vacation, or
After vacation, it will be too late.
Try to get it by 12th of May. Ashu. When did you sit with them, Mr. Banerjee?
4 or 5 months back.
4 or 5 months back.
Even maybe even before. I do not exactly recall the
I'm
dates.
just asking because let me see what this district judge is doing. So that's what I'm asking you. Because you have made your stand very clear.
Correct. I sat in my chamber at least 4 or 5 months back. I do not exactly remember
I'm
that.
just asking for.
But I sat twice or thrice. But I also
Still
could
nothing
not.
has been done.
I also could not make out what they were really trying to say. Subject to my limitation of understanding.
5 months back.
Just certain clarifications, they were saying that.
My lord, if possible, in the meantime, if we prepare the affidavit in opposition, then, my lord,
It will even take longer.
Which is why, I could also not, use any affidavit in opposition, because unless I know the stand of the learned district judge, I cannot also not say anything on those.
Say this is High Court
Well,
stand.
that's the only stand, a one-line affidavit would then come, would be of no meaning.
Ashok. This is an application for implementation of the benefits as recommended by the Shetty Commission and sanctioned by the government of West Bengal. Full stop. This relates to refixation of the pay of the petitioners, payment of arrears of salary, and revision of pensionary benefits of the petitioners. Full stop. Mr. Pal, learned counsel appearing on behalf of the district judge, stroke, respondent number, district judge, not 24 Parganas, stroke, respondent number 3 submits that further time is required to take necessary instructions in the matter. Full stop. Mr. Banerjee, learned counsel appearing on behalf of the respondent number 5, stroke, the High Court administration submits that the stand of High Court administration has been made clear to the respondent number 3. Full stop. It has been clearly stated that the recommendations of the Shetty Commission should be implemented by the learned district judge. Full stop.
Well, this sentence, if can you cast it in some other way? I did not talk to the learned district judge. I talked to the officers. So that is the High Court stand before your lordship.
If I anything, the Mr. Banerjee appearing for the High Court administration submits that the stand, that its stand is that the recommendation of the Shetty Commission should
So
be
grateful.
implemented. Full stop. Next. Who is appearing for the state? Yes.
Mr. Shantanu Kumar.
Mr. Mitra, is representing the state respondents. First up. Next. In view of the submissions made by the parties, this court is of the view that necessary instructions have to be taken by Mr. Pal on the issue why the recommendations of Shetty Commission has not yet been implemented by the respondent number 3. Full stop. Please give me that order. In the said instructions, now, necessary instructions will also have to be taken regarding the stand of the district judge.
My lord,
in view,
this order was modified by my lord. And in the first order, my lord was pleased to direct the accountant as the banker, and that was modified. And the district judge was the dispatched.
The order passed by this court on November 16, 2022 in relation to the employees attached to the district judgeship of Purbo Medinipur. Full stop. The said order was modified stroke clarified by an order dated November 30, 2022. Full stop. Both the aforesaid orders will have to be taken into consideration by the learned district judge stroke respondent number 3 while giving the necessary instructions to the learned advocate appearing on his behalf. Full stop. Next, let the matter appear for further consideration on May 12, 2023, when the necessary instructions will be produced before this court. Full stop. We'll take it under the same heading application on.
My lord, may the High Court administration be favored with a copy of the instructions, my lord, so that we can also, my lord, go through and come and make submissions if at all.
Come, let them serve a copy.
Okay.
Let me first see what he has to say in view of this order that has already been passed. Because today we are in almost end of April and this order was passed in November. What is the district judge doing? Let me see.
That was not concerning because, I believe, there were certain officers who were looking after the matters. They were also, a little bit, in
And
doubt
after you explain to them in your chamber.
Yes.
108.
I'm for the petitioner, my lord. My lord, an application, my lord. And the matter was called, my lord. Advocate on record was seen by the parties.
Service. No one is appearing for the other side. 12th of May. Please kindly come this sir.
It was filed on the 17th of November. But unfortunately, there has been a little bit of delay in preparing this application. I have served on the other side as well. But may I find
You're appearing for?
Lordship, Mr. Shantanu Kumar Mitra is appearing for the state in this matter.
Well, I don't think there would be any impediment in a restoration application on the other side. Well,
where is he?
Lordship, he is in courtroom number 5.
Well, on the last occasion also the other side was absent.
Are you briefed in this matter?
No, Lordship. I'm not in the state panel.
Come back next.
It's an innocuous application.
Yes, he is not here. He is not here. I'll pass it in his presence.
My lord, my affidavit of service we kept on record.
You please keep it with you.
$110.
110. Happy for the state, Your Lordship.
This is application for restoration. Affidavit service.
Within time.
Within time. Please.
Please also for it.
The application is not here before this court. Here. There is some technical difficulty. Come back next week.
Application.
It's not reflecting in the list.
If the affidavit can be kept.
আচ্ছা একটা লিখে আমি আগে করে
Service.
দিই আসুন সবাই আছে তো আসুন by consent of the parties না by consent of the parties the application is taken up for consideration today. Full stop. Next. Why was it dismissed? What happened?
Dismissed for default.
Why?
I
What are
was
the grounds?
I was ill on that day. I suddenly became ill on that day, and I sent when CC
Peruse the
junior
grounds.
advocate. She
Next.
cannot.
Peruse the grounds. Such grounds are found to be sufficient in such view of the matter. The order dated February 17, 2023 is recalled and WPA 20141 of 2022 is restored to its original file and number. Look, bold করে দেবেন restored টা আর ওটা। এক second, can 1 of 2023 is accordingly allowed. Can 1 টা allowed টা। Serve a copy.
Grateful.
Grateful to you.
111.
I beg to appeal for the petition. Restoration application within time. Paragraph 4. Due to my sudden illness, or I could not appear before my lord on that day, my lord.
Date of the order khali niye নিন।
But kindly hear me only. My lord, kindly recall that matter. That's despite having no order of suspension, petitioner was not allowed to join.
This is a restoration application.
My lord, I am coming to that. Until and unless the interim order that was passed by my lord is restored in its original position, my lord, that is at page 12. My lord. Page 12.
Where is your,
In
this
compliance,
is not filed within time.
within time,
How?
within time, my lord.
No,
My lord, it was dismissed on 17th of February. Next page, page 15. And I have filed this restoration application on within February, my lord. 26th February, possibly. Within time.
where is the order dismissal?
Order of dismissal at page 15.
You have filed within time.
I filed it within the time. And my lord, kindly have a look, page 12.
Because of annexure A, I was getting confused.
Page 12, my lord. That was the interim order. And in compliance with the interim order, petitioner was allowed to join. Petitioner joined his service. All the arrears salary has been released. Job has been assigned. And thereafter, my lord, taking advantage of dismissal of this writ petition on default ground, again, they have suspended, my lord. Kindly permit me to, this is the first supplementary affidavit, my lord.
Copy দেবেন আমাকে একটা।
In terms of the order, leave was granted by virtue of an order dated 28th November. That is the first supplementary affidavit. Kindly take up this. Page 7.
Please, 1 minute. Yes.
Kindly take up, my lord, first supplementary affidavit. Leave was granted by virtue of an order dated passed by my lord on 28th of November. My lord, this is my first supplementary affidavit. Kindly have a look, page 7.
Yes,
That was
I have
the-
kept that order in abeyance.
That this was kept in abeyance. Thereafter, kindly have a look the next page. Page 8. This was the order of reinstatement.
Yes.
Sorry, my lord. This was the appointment of the inquiry officer. And my lord, kindly have a look, page 9. Page 9. In compliance to the order dated 28th November 22 of the Honorable Justice, my lord, he is reinstated in the post of supervisor. Page 9.
Yes.
First 2 line. And my lord, thereafter, kindly have a look, page 10. Joining report, joined in service. My lord, kindly have a look, page 11, new assignment of the work, page 11 and 12. And page 13, incremental benefit was also awarded. Page 13.
while he had been discharging his duties as a supervisor and he had been discharging his duties assigned to him, taking advantage of the order of dismissal, my lord, without waiting a considerable period of time, within 25 days, he was again placed under suspension. Kindly permit me to place this supplementary evidence to bring the second order of suspension on record. This is the second supplementary evidence. Kindly have it.
আমাদের কাছে না সেকেন্ডটা নেই
দিয়েছি আপনাকে দুটোই দিয়েছি আবার দিয়ে দেবো রজতকে আবার দিয়ে দেবো kindly have a look. This was the first order of suspension. Page 15, last annexure. It is the photocopy of the first order of suspension, only the date has been changed. And he was again placed under.
Right, it was after the writ petition was dismissed.
Dismissed, taking advantage, my lord, I must be candid.
What taking advantage? The writ petition was dismissed.
Dismissed for default and thereafter again. This is now I am before my lord, since the court was in session and there was an order which was kept, first order of suspension was kept in abeyance.
Yes.
Kept in abeyance.
Yes, they have complied with the order of court.
This is the second order of suspension.
Yes, they have complied with the order of court. There was no petition.
My
petition in the eye of law.
lord. They have complied the order of the
of action. There is no writ petition in the eye of law, my lord, and my lord, at
And
that point of time, they didn't appear also.
when the court
You
is
make necessary application. Why are you holding up the court today?
My
You
lord.
make necessary application, whatever you
My-
can
my-
do under the law.
my lord, kindly restore my writ petition and I will come
And that
with
is what I was trying to do.
and I will come back with an application to bring this on record. And my supplementary affidavit be kept on record.
The two supplementary affidavits filed in court today are retained with the records. Full stop. আর এখানে তারপরে ওইগুলো করে দেবেন হ্যাঁ আর ডেট অফ দ্য অর্ডার ইজ February 17, 2023.
My writ petition is restored.
Yes.
My lord. Give me liberty to file an application to bring this.
No, you have the liberty in law. I am not going to
My
give
lord,
you any
my-
further
my-
liberty.
That is a fresh cause of action because, my lord, after, my lord, dismissal, my lord, the order was passed. So there is no question of, my lord, supplementary and all these things in connection with that
Let him,
previous writ
let
application.
him explore the avenues that is available to him under the law.
My lord.
112.
My lord. Deep lord.
My lord, I beg to appear in the matter for the petition. My lord, this is the restoration applications and matter was dismissed by your lordship on. My lord, unfriend is appearing for the other side, lordship. Within time, your lordship.
I am the state lordship.
Lordship.
Date of the order is November 7, 2022. Hello.
So kind of lordship.
So, my lord, matter is restored and it will appear in
It
usual.
will not appear, they will have to mention. Once it is dismissed, and you have also appeared, taken the trouble to come and appear.
Yeah, lordship. Great lordship. Deeply.
So kind of lordship.
113.
13, my lord, this is my application, my lord. I'm the respondent in the writ petition. It's an application for recalling, my lord. May I file my affidavit of service, my lord.
I beg to appear on behalf of the writ petition.
My lord, lordship was pleased to pass this order, my lord. Recalling of your lordship's order, my lord, dated 1st of March 23, my lord. It's at page 34, my lord. Sending the writ petitioner for ossification test, my lord.
Yes.
But the ground was, my lord, why your lordship was pleased to send, because after the medical examination report by the Apex Medical Board, my lord, which is at page 22, your lordship was of the view that no midpoint has been written, my lord. My lord, kindly see at page 22 of my application, my lord.
Yes.
The lordship was of the view that no midpoint was there. So age assessment as between 35 and 40 years, 35 to, so no midpoint was given, my lord. Now, so your lordship was pleased to hold. My lord, page 35, considering the rival submissions of the parties and the materials placed on record, this court is of the view that in the event a clause is capable of two interpretations, the same should be interpreted in favor of the employee petitioner, because there is a range, my lord, as no midpoint was given, my lord. So your lordship stated, your lordship said that yes, so either it's 35 or 45 years, so the lower point may be taken up at, so 35 he comes within the zone of consideration, the upper age limit being 35 years. But my submission was, my lord, the range is to be taken. Your lordship, now, my lord, I have annexed, my lord, the rules, my lord, which guide. Take the midpoint, my lord. Whether it is written in the age assessment certificate or the report, we have to take. My lord, kindly take up, my lord, page 37, my lord. First. Page 37, my lord. It's a recording of date of birth assessment, my lord, at 38. This is the letter, my lord. The 38 is the guideline, my lord.
39B.
Yes, my lord. Great, my lord. My lord, 39B, it's clear, my lord. It's 5 years range and the midpoint is to be taken.
This must be running as returnable motion before this.
No,
court.
it has not yet come, my lord. It will come, my lord. Now, my lord,
April
page.
11, 2023, it has not come.
No, my lord, not yet appeared.
It is not
yet
appearing
appeared.
as returnable motion.
No, it will come, my lord. Because, my lord,
না না আমি বলছি এটা মেইন রিট পিটিশনটা 11 এপ্রিল আসে।
yes, my lord, thereafter, my lord, may kindly take up page 41. This is a circular of 19th of December 2000, my lord. My lord, it says the age assessment for any of the candidates above the 20 years of age shall be in the range of 5 years. And thereafter, my lord, from page 42, my lord, this is the modalities for processing employment to dependent under NCWA. Next page, my lord, page 42. My lord, kindly come to page 45. I've given the type copy also, my lord. 45, it's at page 46. Thereafter, my lord. After the live roster. Page 46, my lord. Age of the dependent son should be assessed by the medical board while considering his candidature for keeping in the live roster if he is non-matriculate, having no admit card of secondary. So these are not question of live roster, my lord. Thereafter, my lord, next page 47, my lord. It says age range to be reckoned with the of a claimant dependent in case of age assessment. Page 47. Age assessment of candidates below 20 years shall be in the range of 2 to 3 years, and above 20 years, the age range shall be 5 years. Reference circular number such and such, my lord, which I have shown you to your lordship just now, my lord. The midpoint of said range will be taken as the authentic date of birth of the claimant, and for the purpose of precision in the matter of computation, the date of medical examination will be the date to reckon with. My lord, so the midpoint is a midpoint of the range is always to be taken. My lord, now his age was 35 to 40 years as was assessed by us, my lord. So it comes to 37.5 years. Now, my lord, the writ petitioners could not produce any document which is acceptable under section 79 of the Evidence Act. But let them show a single piece of document, only a school living certificate and nothing else, my lord, in the writ petition. So they could not even prima facie prove that their age, his age was less than 35 as on that date, my lord. The writ petition, my lord, there's nothing. Not even the birth certificate. Otherwise, I would have no case at all.
Yes, you want to file an opposition to this?
Lord, I should, because
Action.
My lord, let there be an interim stay of that order, my lord. But otherwise, my petition, my lord, it will become infructuous, my application.
Mr. Das, learned counsel appears on behalf of the applicant stroke Eastern Coalfields Limited within bracket ECL. Moves this application for recalling of an order dated March 1, moves this application for recalling of an order dated March 1, 2023, passed by this court. Full stop. He submits that when the medical board assesses the age of the writ petitioner, the midpoint of the range is to be taken as the authentic date of birth of the claimant for the purpose of computation of his stroke her age in the event the candidate stroke incumbent is more than 20 years of age. Full stop. He refers to the modalities for processing employment
My lord, first the guidelines, my lord.
to the
Yes, that is.
dependent under National Coal Wage Agreement within bracket NCWA, and also the guidelines for recording the date of birth, stroke, assessment of age in ECL. Full stop. Next. By an order dated March 1, 2023, this court had already directed an ossification test to be conducted for assessment of the age of the writ petitioner by a board constituted by the superintendent, SSKM Hospital and IPG MER. Full stop. Next. Leave is given to the writ petitioner to file an opposition to the instant application being CAN 1 of 2023, full stop. Let such opposition be filed by May 4, May 10, 2023, full stop. Let the matter appear for further consideration.
My lord, AR, if
Under the same heading motion,
if
motion
you
which
reply.
application on May 12, 2023. So, what you have already
No,
annexed the
very well,
guidelines.
my
You
lord.
want
I will.
to file- if
No,
required-
I don't want to drag this matter,
Yes,
my lord.
that's why if required, that is the reason.
My lord, if the writ petition comes in the meantime, my lord,
So then the repetition is going to proceed. I have formed a view.
my lord, I think, my lord, test has not yet been done. Was it done? No, not yet been done, my lord. Kindly state that,
Then anyway, it will be kept.
my lord, kindly grant with some protection, my lord, to that extent till 12th May, when the matter is taken up.
Yes, you will be reminding me when it
Because,
comes
my
up.
lord, test has not yet been done, my lord. Ossification test has
Reminding
not yet
me.
been done. In the meantime, if it is done, my lord.
It will be done. That will be done. That protection I can't.
My lord, that is my case, my lord. Why?
I don't know why my learned friend is so afraid of.
No, because once the ossification test is done, my lord, then this application will become infructuous.
This is their board,
My
their
lord,
board is.
no,
I'm not trying to grant any protection. If the ossification test is done, it is done. I am not.
my lord, then kindly, my lord, otherwise my application will become infructuous, my lord.
There is a certificate. Let them come. Let them come up.
My
with
lord,
the
there is no
opposition.
certificate, my lord, there.
Let them come.
There is no certificate which is acceptable under section 79. 10.
That is why I've kept it this side of the vacation.
My lord.
Let me see.
Very good, my lord.
Director, take it.
113. 14. 14.
Lord, I'm appearing for the petitioner in the matter. I filed an application for the extension of the interim relief.
BANERJI is appearing for the respondent. It is kept for final hearing, my lord.
For final,
Is it for, when is your interim order expiring?
it expired on 31st March of 2023. Lordship.
And when have you filed the
30th
application?
March 2023.
Why didn't you mention?
Lordship, I tried mentioning, but the matter was just running in the list all this while in the month of April.
All the matters where interim order is being passed, I am keeping it as to be mentioned and extending the interim order. Why have you not mentioned?
I mentioned 2 weeks ago, Your Lordship.
2 weeks ago, after expiry of the interim order.
No, Your Lordship. It was taken up early in the month of April 2023. Thereafter, it was kept on, I think February, last Friday.
The matter was taken up after expiry of the interim order in April.
After the hearing.
The interim order is till 31st of March. You are saying it has been taken up in April.
It has not been taken up. It was running in the list, but it was not taken
So why did you not mention before
I
expiry?
apologize, Your Lordship, for that.
What is the situation between March and March 31 and today?
Your Lordship, the learned Armed Forces Tribunal Kolkata bench is still not sitting. And we had a very limited prayer in the writ petition that
That order of discharge was kept in abeyance, madam. What has happened between 31st of March and 28th of
nothing
April?
has happened, Your Lordship.
The interim order passed on October 19, 2022 is extended till July 31, 2023. Full stop. With the directions aforesaid, CAN 3 of 2023 is disposed of. Serve of
Audience listed matters, court application under item number 1.
My lord, I have the respondent corporation. My lord, yesterday, my lord, the petitioners have preferred a GA application, my lord, which was emailed to the learned advocate on record for the respondent, my lord, yesterday. My lord, I am yet to receive a hard copy, and may I consider, beseech your lordship to grant me some time so that I can go through the same and come back.
It comes later. There was a direction to file the report by respondent.
My lord, that has been already filed.
Yes, my lord. And it comes to the order dated to the 26 March 2021 passed in this without writ petition. 26 March 2021. Kindly see what was the direction. Kindly comes to the second page of the order. The third paragraph, the respondent corporation. Particularly, the managing director, being the respondent number 3, shall file a report by way of an affidavit indicating the actual deals payable to the members of the petitioner in respect of paragraph 4 of the memorandum dated July 21, 2000. The report shall also indicate up to what period from April 1, 2000 was interest paid and the rate and amount thereof. The report shall also indicate the date on which such arrears were paid. Let a suitable chart in this regard were annexed to such a report. Prior service of the report shall be made to the council. This was that. That report was given to us.
My lord, this is the copy of the report.
What are the dues? Which date it was paid? Doesn't indicate.
You have taken an exception?
No.
Why have you not taken an exception? When was it handed over? Advance copy handed over to you?
My lord, 5th April.
5th April of this year?
Yes.
After Milord payment of cost, your lordship has imposed cost upon them. By next week, Milord, we shall take exception. They have Milord brought in Milord connected Milord tax of other writ petition not connected to us.
My lord, that writ petition is absolutely connected to the present writ petition. Both the writ petitions were filed by the same petitioner, praying for interest on ROPA for their members. In both the writ petitions, my lord, the members' names and details of the members have not been disclosed. Now, my lord, there was a lot of malfunctions which were going on which were committed by the writ petitioner, and that has been pointed out. My lord, first of all, there was a maintainability issue with regard to the petitioner's locus standi, whether the petitioner can at all maintain this writ petition or not. Also, in that particular, the other writ petition, which was heard by a coordinate bench of this honorable court. My lord, in that writ petition, the coordinate bench held that there is a locus of the petitioner to maintain the writ petition, and that was agitated in the before the honorable division bench, my lord. Now, the honorable division bench has heard the matter, and the judgment has been reserved with regard to the maintainability point, my lord. And in there also, my lord, there was the details of the members of Tramazdu Sabha, the petitioner, was not disclosed. Also, the details of the Tramazdu Sabha here has not been disclosed. So, my lord, if at all I am to provide a chart as to the entitlement of the members of the petitioner must at least provide me with a chart of their members. Now, my lord, we have
not stated that in the writ petition.
Yes.
Who are your members?
No.
Kindly comes to page 37 of the writ petition. These are all old stories which are being said. Well, these are being all settled.
No, these have not been settled.
Yes.
No, these has not been settled, my lord. These are.
Kindly comes to page 37 of the writ petition.
What I am saying is that to shorten the litigation, you should provide them with a chart of your members.
You shall take
You provide that. Because
but this is
you are also responsible for lingering the litigation.
True, but this.
My lord, I will say why the chart has not been provided. In that writ petition also, the chart was never provided. Now, my lord, we had to assess later on after the honorable single judge in the other writ petition, when the honorable single judge asked the members to make representations and to provide chart to the concerned respondent, so that the respondent are at least aware that who are the members who are agitating the issue. My lord, chart was provided. Now we had tallied the chart with other writ petitions. Now, my lord, we have found out that same persons who are were before this honorable court in filing different writ petition in individual capacity also. The names of the same persons were there in the list also. And my lord, 3 lists were provided, and the names of individual members were appearing on all the 3 lists, or at least in 2 writs. There were repetitions of names. So these were the anomalies which we have found. Now, my lord, unless and until, my lord, we have a chart here, my lord, we cannot really proceed. And my lord, first of all, the maintainability issue is also before the learned division bench.
This is regarding benefits of open IP. This, my learned friend cannot say that they will pick a class of employees and.
No, that they're not saying, but they have to know whom to pay.
But they have the record. If we have.
So you will provide. If you are the writ petitioner, you will provide the chart.
Kindly will not appreciate one thing. If they have, they say we have repeated names. They have records, they will strike out, and whoever.
That is a different thing.
They will disperse.
If you have dishonestly approached the court twice, thrice, 4 times, they are entitled to take that point. It is very easy to say that they will delete it. But why have you, knowing that you have filed in individual capacity, why have you approached again?
In terms of the earlier order, we have made several representations.
Now you, in this writ petition, you please provide the names of your members.
We shall take exception where we shall disclose all.
My lord, may I submit my report, my lord?
A report on affidavit to the main writ petition being WPO 145 of 2021, as handed over in court today, is retained with the records. Main time to file exception thereto is extended till May 18, 2023. Next, Mr. Otturaj, learned counsel appearing on behalf of West Bengal Transport Corporation Limited, within bracket, WBTCL, bracket closed, submits that a list of members has not yet been provided to the respondent corporation to effectively take a decision with regard to the dues of the members of the petitioner. Full stop. Furthermore, she submits that the maintainability of the writ petition is also under challenge before the honorable division bench of this court. Full stop. Next. Leave as prayed for is given to the petitioner to file an exception. Full stop. In the exception, it will be clearly stated. Now, in the exception, the list of the members of the petitioner will clearly be indicated. Full stop. Let the matter appear under the same heading, court application, on June 9, 2023. Court application on June 9. Server copy.
Grateful, my lord.
Item number 2.
I'm for the respondent, madam.
Kindly speak on the microphone.
Leave encashment, my lord, after the superannuation. Leave encashment was not provided, my lord. A report, my lord, your lordship was pleased to direct the respondent to place a report giving the calculations. My lord, the report, however, does not show any calculation as to what excess amount has been paid. But my lord, an indication has been given, my lord, in page 6 of their report that an amount of rupees 27.
1 second. It is the
My lord.
report dated.
There are two reports, my lord.
Yes, that's what I'm asking. Which
My lord.
report are you
My lord,
referring to?
the second report, my lord, dated.
Dated
18th
1st April.
18th April 2023.
Yes, my lord.
18th April 2023, my lord. My lord, on page
1
6. Yes, my lord.
Yes. Which page?
My lord, on page 6 of the report, my lord, if your lordship comes to para 3,
Yes.
the above mentioned calculation sheet about calculation of pay of the writ petitioner upon conversion of pay and allowances of the writ petitioner Srimati Mrita Mitro, ex-manager general in the IDA pattern of pay scale from CDA pattern of pay scale has been available from the concerned divisional office depot, where it has been found that upon such conversion, a sum of rupees 27,440 is recovered from the petitioner on that account, as the said amount being received by the petitioner in excess during the material period. Your lordship, my instruction, my lord, in the writ petition, I have also annexed another, my lord, order from this honorable court of a similar situated employee, my lord, whereby the leave encashment was released after deduction of the excess amount. My lord, my prayer is, if this is the amount, if, my lord, let them release the amount deducting the excess, if any, because it has been provided to other, my lord, employees as well.
1 minute.
Your lordship, my lord, if your lordship comes to page 21 of the writ petition, I have annexed another order, my lord.
Yes.
My lord, my lord, as far as this amount of recoveries is concerned, my lord, that is there, my lord. But the stand of the, my lord, Food Corporation of India is this, my lord, there is difficulty. Difficulty is, my lord, there is a little background fact behind this, my lord.
There is?
Some, my lord, background history behind this, my lord. What is the difficulty, my lord? Difficulty is, my lord, this is, my lord, the dispute is arising out of the conversion of pay scheme, my lord, from central dearness allowance to industrial dearness allowance. So there was a circular first published by the Food Corporation of India in the year 2011, my lord.
Yes.
So as to, my lord, convert the pay scheme from CDA to IDA. That, my lord, circular was put into challenge before the, my lord, Honorable High Court at Delhi, my lord. In Delhi High Court, my lord, there was order passed whereby, my lord, the corporation directed, my lord, to not to release any areas, but so far as the recoveries is concerned, arising out of this conversion, my lord. In other words, recoveries can continue, but as far as the release of areas is concerned, that is to be put on hold. So in pursuance thereof, my lord, the
Release of areas.
release of areas, because, my lord, because we convert.
That is a separate issue. Now they are wanting payment for leave encashment benefit.
My lord, in respect thereof, my lord, the FCI again come out with another circular in the year 2013, whereby adopting the direction passed by the Delhi High Court, my lord, the corporation has decided, rather, my lord, that rather put into force that all the, my lord, what are the payment is to be made, my lord, that is to be put on hold until that High Court, that decision is, my lord, is finally, my lord, it adjudicated, that issue is finally adjudicated. Because the difficulty would be, my lord, if, my lord, the league encashment is calculated under CDA, then X amount would be, my lord, calculated. And if the, my lord, the leave encashment is calculated under IDA, then Y amount would be, my lord, the come to, my lord, the after the calculation.
Both the X and the Y amount. I asked you, you should have put, you are saying according to you, in the
And if, my lord, excess amount is paid, my lord, then there will
the IDA pattern of pay scale 27,440.
that has
is
been
due that
adjusted from
payment.
her, my lord, her salary, my lord, that has been already been, my lord, recovered. But as far as leave encashment is done, my lord, the calculation, we are at loss, my lord, under which heading we'll calculate, because CDA, another one figure will come, and IDA amount.
Should have put that on the
Pay
record.
the admitted amount.
Pay the admitted amount. You should have put that you have filed.
I have the instruction, my lord, if the, my lord,
Please try to understand. You have filed 2 reports on affidavit.
lord.
This problem has to be solved. What, there must be some amount that is
Yeah,
due and
absolutely.
payable.
I appreciate, my lord.
So
Some
that
amount is
amount
payable.
has
I
to be
cannot
paid.
dispute that, my
What
lord.
is the point in filing 2 reports on affidavit if I cannot get the amount from these reports?
I understand, my lord, but this is the stand, my lord.
File another one upon payment of costs to them. What do you want to do? Tell me.
Amount of cost is already paid. What I can.
Then again, third report I will have to direct. Because in these two reports you have not indicated. Now tell me what you want to do. Is this a fair
I
stand?
can give, my lord, 2 calculation. I leave
The
it to your
fair stand
lordship.
that you are taking.
See, because my difficulty regarding the recovery, if the excess, the event, my lord, the 2011 circular is set aside, and if I pay.
You have calculated this, the whatever you have recovered under the IDA's pay of scale.
That is
Now you
from a-
should have given me both the amounts.
My lord, they kindly give me another opportunity, last
Another
opportunity.
report.
Another report. As a last time.
The stay order was vacated by the Honorable Delhi High Court way back in 2013.
Okay.
একটু পড়ে তারপরে কথা বলতে শেখো। This is in respect of one of the employees who had sought for implementation of the circular. But kindly takes paragraph 3 of that order. But the employee's claim was rejected in that case. To be noted, by order dated 29th May 2012, the operation of circular dated 30th September 2011 and office memorandum dated 10th August 2009 was stayed. The stay was vacated with the order dated 22nd February 2020.
That was regarding circular, my lord. As far as our circular is concerned, that was not put on the stay, my lord. And as far as the Delhi High Court order regarding release and recovery, that has not been changed, my lord. So this stay has, my lord, is not changing any, my lord, the situation as far as we are concerned, my lord. But nevertheless, my lord, out of court, I can submit, my lord. Definitely one amount is payable to her. Now difficulty is CDA or IDA. I may come up with both the figures, my lord, as a last chance, my lord. Thereafter, my lord, I'll leave it.
You see page 18 of the report, not it. I don't think that there is any requirement of filing any further affidavit. Please see page 18 of the report. And the paragraph beginning with the words now in respect of WPO. Your Lordship has kindly got that. It is again reiterated that FCI circular of 2013 was issued in consequence to the interim order dated 22nd February 2013 of Delhi High Court, which stated once it is found that the petitioners have received in excess, interim orders cannot be passed to the effect which is to grant relief of recovery of money to the petitioners, inasmuch as the issue of entitlement will necessarily have to be looked into and decided at the time of disposal of the petition. In case, however, the petitioners succeed, the court can pass appropriate orders for payment of the amounts due to the petitioners along with interest. Surely the employer can always make the recovery when admittedly amounts are taken by the employees which are legally found not due to them. From the said interim orders, it can be deducted that the Delhi High Court has essentially held that the rights of the employees are to be adjudicated before entertaining any claim from such employees. Also, FCI circular of 2011 stands regulated by the subsequent circular of 2013, and applicant cannot stake claim on the basis of circular dated 30th September 2011 alone. The corporation had issued circular of 2013 partially regulating circular instructions of circular dated 30/9/2011, as there are a large number of employees who have retired or retiring from services of the corporation, and if amounts are paid before adjudication of their entitlement, there will be no way to recover such amounts if the decision of the court on entitlement is otherwise. Further, in the following matter, FCI conducting, I'm not on the advocate's case, please kindly take note the next page. Not immediately probably the fourth line from the first, from the
Bottom.
the sentence begin with the word querist will be at liberty to bring correct facts. But it is in the first paragraph, third line. The querist will be at liberty to bring the correct facts to the notice of the Honorable Calcutta High Court in season of the writ petition being filed by so and so. The querist has taken the stand before the Honorable Delhi High Court that the said circular of 30th September 2011 is perfectly valid in law and ought to be implemented and given effect to. If the Honorable Court upholds the contention of the querist, there would be no impediment in granting the relief sought by the employees such as Mita. To the extent of their lawful entitlement under the circular of 30th September 2011. However, till then the hands of the querist are tied and hence the relief paid by under the said writ petition pending before the Calcutta High Court cannot be granted at this stage. As such, the querist is advised to bring the above facts to the notice of the Honorable Calcutta High Court, praying that the final relief sought in the above mentioned writ petition be kept in abeyance pending final adjudication of the matter. That interim order was vacated long back.
No, interim order has not been vacated. As far as stay is concerned,
I think you please let me know what is
my
that
lord.
that is
My
given
lord,
payable
under
on
both the
account
headings,
of
my
the
lord.
encashment benefits
Under both the
under both the schemes.
My lord.
It's 300 days, so it's 8 months salary. If it is IDA pay scale, what would have been the
My lord, my lord.
amount?
What is their
My lord.
calculation?
I
My
received
lord,
the adjudicate amount.
Yes,
The other we kept in abeyance.
My lord.
that is what I.
That's
My lord, my lord,
That's upon him. That he has paid some cost. He has filed 2 reports. Now, if nothing appears from them, what can be done?
It's going on for the last probably 8 months now.
Ashu, will you submit on instructions or will you file another report?
I'll better file my report.
Another report.
My lord. Within time only I'll file the report, my lord.
Within time, we'll file this time.
It's a calculation not
Whatever
which the
the
accountant can do within 1 hour's time.
My lord, know that this kind of, my lord,
Now
it
all
takes some time.
system generated 300 days leave encashment at IDA pay scale and CDA pay scale is probably 1 hour's calculation time required.
But in that way, my
Everyone is
lord,
as
the
fast as
public
you are.
entity
Not
does
as
not.
But one has the
People might
one has
take
the
a
will
little
one
more
has the
time
will to do first before he actually does.
People
Does.
might take a little more time compared to you.
One has to have the will first.
Mr. Borban, Learned Counsel appearing on behalf of Food Corporation of India, in bracket FCI, submits that another report and affidavit is required to be filed on behalf of the respondents, giving the calculation for 300 days of leave encashment benefit that may be due and payable to the petitioner under the CDA
As well as IDA, my lord.
way of calculation and IDA pay scale of calculation. Full stop. How long will you take?
2 weeks, my lord.
How long?
2 weeks, my lord.
Park Street office. Middleton Road. Not Park Street, it's Middleton.
Only to avoid the, my lord, an unwarranted situation so that I may not seek for further adjournment.
Get such report on affidavit be filed by May 10, 2023 upon service of an advance copy to the learned advocate appearing on behalf of the petitioner. Full stop. Let the matter appear under the same heading court application on May 12,
May 12, my lord. On the other day
that is
also,
the last
my lord, I understand.
Friday
My lord.
I'll get
Another
before,
matter also,
the
my lord, I
supplementation.
sought indulgence of this court. This matter only, my lord. That is what the
Maybe
matter.
a week before then.
My lord, I'll be out of station, my lord.
So Mujum, the week before the Friday is not a working Friday.
Oh, well.
But next available Friday, my lord. Only difficult, I won't be here, my lord. That is only difficulty, my lord. I'll prepare the report and serve upon my learned friend as well in time. That I can undertake, my lord.
Let the matter appear under the same heading court application on June 9,
Extremely deep, my lord.
2023. Court application on June 9 to bold করে দেবেন.
Deeply obliged, my lord.
The report be circulated before the
I
vacation.
have said that.
My lord. I'll do that, my lord. Biplab Raj.
Item number 3,
My lord, I appear for the respondents. I had a talk with Mr. Ghosh, my lord, in the morning.
Has prayed
He has
for-
difficulty. My lord, only thing is that we have exchanged the report and the exception. Let it be kept with the record, my
Ashu.
lord.
Ashu.
Item number 3.5.
Same orders, যেটা 3 তে হচ্ছে same order টা 5 এ করবে। Report on affidavit and exception thereto are retained with the records. Full stop. Let the matter appear for further consideration on June 9, 2023. Hold it under the same heading, court applications. Five track पे देखे।
5 to.
My lord, 9 is also there, my lord, but.
1 second, just let him call.
Yes, my lord.
Item number 4,
My lord, which date?
My lord, on
Ninth
behalf
of-
of the,
9th of June.
my lord, item number 4 on behalf of the petitioner paying for not today, my lord, Mr.
My lord, I'm-
9th of
My lord. Great.
5 to হয়ে গেছে তো? 5 to complete. Item number 6,
Yes, I'm praying for not today.
9th of June. Petitioner has paid for time, madam.
item number 7,
My lord, I beg to appear for the respondent. My lord,
Mr.
I
Ghosh
came
has
to
made a
know, my lord.
request in the morning,
Yes, my
9th of
lord.
June.
My lord.
item number 8,
8,
item number 7 তো হয়ে গেল।
you're for the petitioner?
My lord, I'm for the petition, my lord. Mr. Jishnu Chaudhary is appearing in the matter, my lord. He's visiting another court. I'm praying for
9th of June.
My lord, I'm
My
for
lord.
the respondent.
get
Item number 9,
My lord, I appear for the respondents in my lord.
Not today.
9th of
9th of June.
item number 10,
Lordship, I'm for the respondent.
I'm for the petitioner also, Mr. I'm appearing for the state respondent LAPITA. State, yes, but answer. And also in this matter, the district magistrate.
Yes,
The husband died on 2020. The petitioners are the wife and the son. They made an application for employment to the son.
yes.
The respondent then sought for the verification.
Now tell me
between
when the husband died in harness.
husband died in harness. Then the respondent authorities sought for the verification between the petitioners.
When has the husband died in harness?
24th November 2020.
And when have you made the application?
I made the application on 18 January 2021.
January 2021, yes.
One.
Yes, then
Thereafter, the respondent authorities sought for police verification to ascertain the genuinity of relationship between the petitioner and the deceased employee. But till now, the verification process has not been completed. Finally, direct them to
where is the office order regarding police verification?
it's in
Lordship, page, annex to P11.
P in there. Page 41.
41.
Who is appearing for the state?
I'm appearing for the state.
What happened?
Lordship, kindly come to page number 33, Lordship. One.
Yes.
Lordship, I'm reading the between lines, Lordship. I am the IO of this. I'm reading the second paragraph, Lordship. Second paragraph. This is the this letter has been forwarded by the ASI to the block development officer.
Yes.
Lordship, I'm reading the second paragraph, second line, Lordship. As I am the IO of this case, I received containing page number 1 to 9 of the above noted memo reference from OC HON'BLE PS regarding inquiry of the material, wherein during inquiry it is found that in page number 5, as per ECL service book of late Ashok Bahadur, there is no such reflected in the name of Bikram Bahadur in details of the dependents relation as per Form B register reference number such and such 1710, which is also verified physically by me at ECL Administrative Center Authority of the same. And I have asked and requested on several occasions about the dependent relation has in Form B register reference number 1710 of the deceased Ashok Bahadur, identity card number such and such, but claimant could not furnish their whereabouts as well as their death certificates, or if any in the name of Ratan Bahadur, Shrimati Buri Bahadur, Miss Kalabati Bahadur, which is incumbent for assigned inquiry in precise containing page number 1 to 9. So in this regard, it is worth mentioning that the dilemma regarding in the above in the second fraction, which is fully part of the discussion for an adjudicator of ECL authority. So unless this could be provided for this reason.
Yes, after that, she is referring to the ECL's 3 members committee's report dated October 17, 2022. This is after this inquiry report.
Eastern Coalfield এটা ব্লক ডেভেলপমেন্ট কে পাঠানো হয়েছিল কিন্তু ওরা না ইয়ে করে লর্ডশিপ মিস্টার মুখার্জি
I'll direct the district magistrate to file a report.
Lordship, one thing I would like to just.
You are appearing for, madam?
I'm for Eastern Coalfield Limited.
Yes.
I'm just trying to indicate your lordship two points, your lordship. If my lord kindly come to the page 46,
Yes.
that is the birth certificate.
Yes.
There, your lordship will find that the date of birth has been, my lord has got it.
Yes.
The date of birth stated is 31st October 2002. And the date of registration is 15th of February 2002. So, your lordship, this document, there must be some anomaly in this document, your lordship, because the dates are not the same. And apart from this, lordship, the relevant instructions that I have received, your lordship, these letters, your lordship, have not been received. Now, if my lord direct, I can file a very short affidavit, your lordship, if you're my lord.
No, that is not required. First, let me see, because I already have your document at page 41.
Lordship.
Now I have to inquire and find out. That's the only thing that is relevant. Ashu, because there are anomalies, you have not considered the application. The petitioner number 1 is the wife of a deceased employee,
lordship,
stroke, worker.
Appointing authority, the Eastern Coalfield Limited.
That I know.
And my lord.
1 minute, Mr. Mukherjee.
Yes.
And the petitioner number 2 is the son of the deceased employee, full stop. The deceased employee worked with the Eastern Coalfields Limited within bracket ECL and died in harness on November 24, 2020. The petitioner number 1 made an application on behalf of petitioner number 2 on January 18, 2021 for appointment of the petitioner number 2 on compassionate grounds. Upon consideration of the said application for compassionate appointment. ECL noted certain discrepancies in the documents produced by the petitioners. Full stop. An inquiry was made with the block development officer within bracket BDO. From the inquiry report of the BDO, it appears that the relationship between the petitioner number 2 and the deceased employee was not very clear. And the claimants, stroke petitioners, would not assist the BDO by furnishing the relevant materials. Full stop. Thereafter, a 3-men's committee was formed at the area level of the ECL to ascertain the genuinity of the relationship between the petitioner number 2 and the deceased employee. Full stop. The petitioner number 2 was required to appear before the committee on October 19, 2022. Full stop. What has happened in that?
Lordship, thereafter, your lordship, that instruction I have to receive, your lordship.
Full stop. Learned counsel appearing on behalf of ECL submits that further instructions are required to be taken in the said matter. Full stop. You bring the instructions on 12th. Let necessary instructions be taken and submitted before this court on the adjourned date of hearing. Mukherjee Learned additional government leader appears on behalf of the respondents number
8,
8,
9 and 10.
8 to 10. Full stop. Let the matter appear for further consideration on May 12, 2023, whole day, under the same heading, court application. You bring your instructions and then I'll direct the district magistrate.
The matter ought to have been moved in appellate side. All the respondents are in the outside disregard order.
No, they are within West Bengal.
Can you see first disregard, second Question Bardhaman, third Question Bardhaman disregard, fourth?
Yes, within West Bengal. No, this is clearly.
No, appellate side of this honorable court.
No, because this has been clearly held by this court. It is, in case of an writ petition, it is a matter of administrative convenience. Which side?
No, I'm not saying that. Original side, appellate side of the writ jurisdiction.
No, in case of a writ jurisdiction, whether it will be filed on the original side or the appellate side, I am also saying on the same point. It is a question of administrative convenience.
No, I'm not saying that administrative, but all the offices of the respondents.
As long as it is within the state of West Bengal, it can be filed in any of the sites.
Original Jurisdiction Act 1884.
I can show that, I can give the reference of that judgment.
Justice Bannerjji Rai said in 1987-88 that only from the stand.
Premlata Devi, division bench has held. Justice Vishwanath Sharma, the division bench has held. It is a question of administrative convenience, whether it will be filed in the appellate side or in the original side. That judgment, I'll give it to my court officer. You know that judgment, Mr. Mukherjee.
And another.
I'm sure you know that judgment.
কবে থাকবে এটা?
12, বড় পাঁচ। Item number 11,
I'm praying for not today.
9th of June. 9th June.
item number 12,
Your Lordship, I appear on behalf of the Eastern Coalfields Limited led by Mr. Arifin, Your Lordship. Mr. Arifin has been instructed to appear in this matter. We have not received the copy of the writ petition, Your Lordship. Kindly direct them to serve us a copy of the writ petition.
In this matter, did I appoint Mr. Arifin?
The ECL authorities have instructed him.
One of the matters I have.
Yes, Your Lordship,
did he
we
get
have,
the-
yes, Your Lordship.
Not today, Your Lordship, not today.
I'm praying for not
9th of
today.
June. In the meantime, please do the needful, madam.
Right, Your Lordship.
good. Restoration application, item number 13.
Lordship, Mr. HON'BLE is appearing for the petition and he's out of station. Lordship, praying for 1 week adjournment.
12th. Grateful, Lordship. 12th of May.
For hearing, item number 14.
Appearing for respondent bank, my lord.
Yes.
This is withdrawal of certain allowances from the officers in scale 1 to scale 5 of State Bank of India by reason of not passing an examination. Your Lordship may kindly recollect that there are 5 allowances granted to the officers and 3 to the workmen category. If I don't pass this examination or this is termed as non-learning, I earn disincentives. Disincentives in the form of not being able to be promoted or not being able to be considered for promotion in the next higher rank. It's being given to the suspended. Some of these 5 allowances are also being given to the suspended officers.
You will be making your submissions today, Mr. Sinha? On the last occasion you took time. Will you be making your submissions today?
I'll make submissions.
Yes.
But I will take some time.
Yes. I'll release that. No matter, release.
The other matters are released for this day.
Well, I prepared a very short note. If your Lordship may kindly accept this. This will shorten the length of my argument, not whatever what it is. But we are concerned with officers from scale 1 to scale 5. That they get 5 in 1 allowances. Now, these are the 5 allowances which they get. And the said allowances are determined and realized on the basis of deliberation and even recognized at the level of IPA. The background and purpose for introduction of each of these allowances are disclosed. Not what are the purposes for these allowances being introduced, not I have indicated in the respective page numbers. But conveyance was to mitigate the hardship caused by the inflated price of fuel. Newspaper and magazine is to upgrade an officer's knowledge insofar as the banking activities are concerned. Cleansing material is for upkeeping the accommodation of the officers. Labor charges is for the self-same premises, and internet, broadband and mobile connection is dedicated for the purpose of not the officers were at the branch level. And that's a particular number given to that officer. He has to surrender that number once he's transferred from that place.
For getting business for the banks.
These are the purposes for which the allowances were introduced. Vis-a-vis the workmen, they get these 3 allowances: conveyance, entertainment, and newspaper. But in 2014, this mandatory learning was introduced, which they wanted to link with the allowances. But not although introduced in 2014, it was kept in abeyance by reason of various deliberation and not negotiation. Now, the outcome of this mandatory learning not being completed is, I will not get these allowances attached to my salaries, the financial impact thereof is 10,000 to 26,000 rupees per month, depending on the rank of the officers, from scale 1 to scale 5. Now, the stand of the bank, as in paragraph 7 of the note, is it is not a right, but it is a privilege. Now, to this note, my response is the impugned letter at page 93. I just showed your lordship the impugned document only from my writ petition. Page 93 in volume 1. Withholding of 4 in
Officers who didn't complete within February 2023.
yes, not there are certain officers not there. It's every year this time period is fixed.
Yes, you said that last time. I think you said that within February.
Yes, I filed an application because not when the interview was refused, I was on the time during which I had my officers had to my members had to complete their mandatory landing. Now on the second occasion I came before that cutoff date was to expire. So I filed an application.
What is happening now?
Not the same position. Not I have some of the officers are not completed by February 2013 and they are continuing to get less pay. But I need to place this document at page 93 at some length. In terms of the mandatory learning guidelines for employees up to scale 5, SMGS, senior management grade scale 5, all employees are required to complete their role relevant certification program and certain mandatory e-lessons for the mandatory learning score in CDS. The officials working in specialized domains, namely credit, forex, risk, treasury, and accounts, are required to complete specified RBI mandated certification. The employees who do not get the mandatory learning score are not entitled for AAA grade in CDS and also not eligible for promotion. So that's the first consequence. The consequence is a marking in the ACR. Resultantly, I do not become eligible for promotion. That's the consequence of not learning. Officials in TEGS1, that's the grade, and above grades are also required to complete mandatory learning requirements in terms of completion of EDX courses so and so. Detailed guidelines of mandatory learning for all officials or employees up to TEGSS2 are reviewed or issued every year. The past experience indicates that certain officials are reluctant to complete their mandatory learning. As mandatory learning is necessary to improve the official's job knowledge and reduce the operational risk on account of lack of knowledge, it is felt that certain disincentive needs to be introduced for non-completion of mandatory learning. Accordingly, it has been decided to implement the instructions for completion of mandatory learning with effect from 1st April 2021 as under. Please come to 4 and 5 on the next page. If an official completes mandatory learning in the month of January 2022, he or she shall be eligible to claim the allowance for the month of January onwards, only after updation of mandatory learning completion in HRMS. So if I complete within a particular cutoff time or month, I continue to enjoy these allowances for the rest of the year. If an official completes mandatory learning in the month of February 2022, he shall be able to claim the allowance for the month of February onwards only after updation of mandatory learning completion in HRMS, and the allowance for January 2022 shall be forfeited. Officials retiring during the period 1st January to 31st March will be exempted from the disincentive. So not this allowance payment, or not what they call as privileges now, although not there are documents galore in the writ petition and the bank's own correspondence which describes this payment as allowances. They now seek to contend that if I don't complete this mandatory learning, then it will earn a disincentive. And what is this earning of disincentive? I don't get these allowances, which are attached to certain objectives or objects which have no nexus with this sought to be achieved. Because even a suspended employee is entitled to certain allowances out of these 5. Not maintaining the furniture, newspaper, mobile broadband, conveyance. These are in no way connected with this, as will appear from the purpose for introduction of these allowances. Now, to show that this, that my main contention is that this imposition of this condition has no nexus with the object sought to be achieved. That's my primary contention. Now, to show that the suspended employees are getting the benefit of some of these allowances, if you turn over to page 108 in the first volume itself. This is part of the service rules of officers. It's Officers Service Rule 68A, Clause 7, Sub Rule 7, Clause II. The Central Board of the Bank at their meeting held on March 30, 1994 approved the amendment of Rule 68A7 of the SBI Officers Service Rules to read as under. During the period of suspension, an officer may, subject to such guidelines as decided by the Managing Director, be allowed occupation of such official accommodation as to be decided by the bank, but shall not be entitled to free use of the bank's car or receipt of conveyance or entertainment allowance or special allowance. The administrative guidelines in this regard are stated below. But, kindly have a look at 7. The rental ceilings will be as per the place of stay. The following facilities will also be allowed to the official under suspension: residential telephone, cleansing materials, reimbursement of casual labor charges as per rules. Now, B and C, these are relatable to the premises and occupation of the officer. Nothing to do with employment or being in active employment rather. Now, this admission of the bank has admitted that the officers who are under suspension are entitled to these allowances, these 3 allowances, is in page 15 of the opposition. I have indicated this in my notes. I can also place that paragraph for your lordship's kind consideration. Now, it's page, I'm sorry, paragraph 15, page 21.
Paragraph 15.
At page 21 of the opposition. That with reference to the statements made in paragraph 13b of the said petition, save and except what are matters of record, I deny and dispute each and every allegation made therein. The officers cannot equate their promotion prospect with the suspended officers against whom disciplinary proceedings is either apprehended and or initiated. Now, that's what the bank not subconsciously admits. This could at the most be a promotion prospect. Then, bank does not take any official work from the said employees during suspension period. Suspended officials being exempted from mandatory learning are also out of the purview of 5-in-1 disincentive. It's a clear admission that whatever is payable to the employees under suspension continues to be granted to them.
So the officer who is rendering his or her service will be at a disadvantageous position compared to a suspended officer against whom the bank is contemplating disciplinary proceedings.
That does not stand to any reason or logic or any rationale. Now, my lord, so far as the consequence of non-learning, your lordship may, I have shown to lordship pages 90, that page 94. Lordship may also take page 99 apropos that paragraph 15 of the bank's opposition, not where the bank stated that promotion is different from a suspended officer's position.
Paragraph.
Page 99 of the repetition in the first volume.
Yes.
Kindly take note the previous page, page 98, the last paragraph of page 98. It refers to certain RBI mandated certifications. As per RBI stipulations, only those officials who have completed RBI mandated certifications are permitted to work in the specified domains, namely so and so. The mandatory learning score will be awarded to these officials only upon completion of the specified RBI mandated certification and upload in HRMS, and completion of any other internal or external certification during the current year will not be eligible for mandatory learning score. So that's really the purpose of introducing this mandatory learning. The 98 of the repetition. There are certain RBI mandated learning syllabi or say scores, which if an officer concludes during a specified time period, it adds up to his scores for the purpose of promotion. And that's why the bank in its opposition used the word promotion vis-a-vis a suspended employee. He is not incumbent for promotion. Therefore, this disincentive will not apply. But if this is to be treated as a disincentive at all, it has to be relatable to that page 98, the purpose for which it was introduced. Then what I say that from scale 6 onwards, this is not applicable to them, to the officers. We that there, of course, but if there are different categories of officers, each rank is to be treated differently. Right? Don't join much issue on that. But then not kindly take note the third page of my argument, fourth page of my argument. In scale 1 to scale 5, there may be very many officers posted in various disciplines. Say, my lord, a civil engineer who is say a scale 4 or scale 5 officer, a medical officer who may be a scale 3 officer, they are also losing these allowances. If page 98 of the writ petition being the RBI mandate, the foundational stone for the that's
That
the
will be an issue, a bone of contention.
but that's the chance of promotion is not a right. A chance of promotion is not a right. Not by reason of my placement in a particular discipline, I either expose myself to certain liabilities or I entail myself to certain benefits. But over that placement or deployment, I don't have a hand. I don't have a role. But suppose there are certain expert fields, say the medical officer or an engineer of a bank. They can never be deployed in the core banking business activities. But of course, they are integral part of the bank. But the question larger issue. But if certain allowances are payable from scale 1 to scale 5, depending upon certain factors, then can this withdrawal be permitted on
Primary
primary
of the
question?
matter.
That's not paragraph 7 of my note.
Paragraph 7 of your note.
Yes.
Paragraph 8. Paragraph 7.
I'm sorry, paragraph 8, paragraph 8, paragraph. Now, this is one aspect of the matter. The other aspect is the policy itself envisages the consequence of non-learning.
Yes.
That is closure of promotional avenue and ACR being written in a particular manner without score being one.
Like a default clause
Yes, like a default clause.
in a contract. Yes.
Now, once I know the consequence and then voluntarily decide not to participate in the learning process, whether I can be made amenable to a different effect altogether.
More impositions. Yes.
Like a show cause notice. Suppose not I have participated in a tender, knowing that I have to disclose this in a true and proper manner. Now the bidding, the authority, the government finds my bid to be lacking in certain particulars. A show cause notice is issued to me for blacklisting. I know the show cause would entail to a blacklisting or debarment for a particular time period. Now the policy is, if I don't do this, I meet the consequence of not getting marks and not being promoted. This is the second limb of my argument. The primary limb is this allowance being introduced or now being sought to be inducted with or joined with these allowances has got no nexus. Just by way of an example, if your lordship will kindly have a look at page 60. I have shown to your lordship page 98. What was the RBI mandate? 60. Now, this is for conveyance expenses. It's in fact, it was introduced sometimes in early 80s. Reimbursement of conveyance expenses. We have requested your good self to enhance the limits as the need for the officers to move out frequently for business mobilization and for customer contacts under the present banking environment of severe competition has increased. Now kindly take page 64. It's always done through deliberation and then introduced. In terms, immediately after the chart. Reimbursement of 4-in-1/3-in-1 conveyance expenses, cost of newspaper, magazine, casual labor, cleansing materials. In terms of the extant provisions, officers in different grades are entitled for reimbursement of various monthly perquisites, namely conveyance expenses, cost of newspaper or magazine, casual labor and cleansing materials depending upon the grade or scale of the official and executives. It has been decided to modify the process of payment of miscellaneous benefit under this head on certificate basis with self-approval facility and revise the existing ceiling of some of the miscellaneous perquisites as under. Not depending on the position of the officer, not his ceiling has been raised or revised. Kindly take note the next page 65. The last column of the last paragraph of that page with a beginning with subparagraph 4. Reimbursement of conveyance expenses, officers JMGS 1 to SMGS 5. At present, officials are reimbursed conveyance expenses as under officers maintaining vehicle 4 or 2-wheelers, reimbursement of fuel cost on declaration basis. Where vehicle is maintained at workplace, officers maintaining vehicles or reimbursement on certificate basis, officers not maintaining vehicles and using public transport, reimbursement on certificate basis. Then please take the next page. At present, reimbursement of conveyance facility is being made on the basis of quantity of petrol consumption cost per liter. That's the rationale and object. And similarly, not for newspaper or magazine. Please have a look at 72. Paragraph 2. In the light of increase in competitive environment in which the bank is operating, our officers must keep themselves abreast of the developments in technology, human resources, finance, marketing and commercial matters so that they become well equipped to face challenges and deal with the issues in a professional manner. Then paragraph 3 refers to the meeting held on 24th November 2006. Then please have a look at paragraph 4. The last 2 lines of that paragraph. The revised ceilings of reimbursement of the cost of newspaper magazines are given in a table as per annexure 1. The above revision in the amount of newspaper or magazines will be effective for expenditure incurred with effect from 1st November 2006. Object being spelled out in paragraph 2, read with paragraph 4. Now, not for cleansing material, not which is payable even to the suspended officers. Please have a look at page 74.
I think I was prima facie of the opinion, maybe remotely connected with the object of mandatory learning.
Yes.
This expense.
Newspaper.
Other expenses, how can, may not be connected with the object of mandatory learning according to you.
Yes. But whatever, every action of a state has to be informed with reasons. And I don't need to cite case laws for that. Number 1. Number 2, the basic object of Article 14 or not the basis of Article 14 is the action must have a reasonable nexus with the object sought to be achieved. Reasonable nexus with the object sought to be achieved. If the introduction was with a different object, withdrawal cannot be for a different object.
The impugned notification is dated April 30, 2021.
Yes.
And these benefits were being paid to you from much before.
Since long, I have given, if your lordship can take the note. Page 19 is the introduction of conveyance allowance. It's in the early 80s.
Page
19, please take the note.
Note.
First page number referred to is in paragraph 3A, page 19, against conveyance, against the heading of conveyance of the note. First page of the note. Paragraph 3A. Conveyance. Please see the date of introduction, 1983. Officers who maintain vehicles with a view to alleviating their financial hardship due to rise in the price of petrol. (22A). Even the IBA had deliberated on this. Please have a look at 22A, which is part of Executive Committee of the Central Board's decision regarding reimbursement of conveyance expenses to officers. Please have a look at paragraph 5 on page 22A. The Personnel Committee of the IBA, after lengthy deliberations, formulated a scheme for reimbursement of conveyance expenses and submitted it to the Managing Committee of the IBA for approval. The scheme was subsequently discussed by the managing committee and it was decided by the committee to elicit views of the public sector banks regarding implementation of recommendations of the personnel committee uniformly in all the banks before a final decision could be taken by the managing committee. Then it went on to deliberation further and negotiation. It was introduced at certain levels. From time to time, the ceiling had been revised depending on the cost of fuel. Page 39 by way of an example. Reimbursement of petrol expenses on production of actual receipts for the officers maintaining vehicles. Limit for reimbursement of petrol cost per month subject to production of bills for use of own vehicles.
Yes.
Now, insofar as Article 14 is concerned, I think it has been, the paragraph number has wrongly gone down in the note. It should be paragraph 24 in the SCC.
Paragraph
18 কোথা থেকে আসছে? শিল্প করো না তোমরা SCC র এটা আগে কেন? 2010 3 SCC 314. Paragraph 18. But the question which the court was answering was not coined in paragraph 18. The paragraph beginning with the words that leaves us with the question whether any imbalance among those eligible for appointment against class 2 category 1 posts coming from different sources and categories would itself justify a classification like the one made in note 6. Our answer is in the negative. There is no gainsaying that classification must rest on a reasonable and intelligible basis, and the same must bear a nexus to the object sought to be achieved by the statute. By its very nature, classification can and is often fraught with the danger of resulting in artificial inequalities, which make it necessary to subject the power to classify to restraints, lest the guarantee of equality becomes illusory on account of classifications being fanciful instead of fair, intelligible, or reasonable. And I submit that this is not reasonable, not fair, not intelligible. Now the other judgment 2000, it quotes not the earlier view only.
One second. Yes.
And the other judgment is 2015 to SCC 712, paragraphs 24 and 25. And it quotes, it is now well settled, established that while Article 14 forbids class legislation, it does not forbid reasonable classification for the purposes of legislation. In order, however, to pass the test of permissible classification, two conditions must be fulfilled, namely that the
Paragraph 24.
24.
It is now well established from there.
Yes, no, it's the quotation within quotes. It is now well established that while Article 14 forbids class legislation, it does not forbid reasonable classification for the purposes of legislation. In order, however, to pass the test of permissible classification, two conditions must be fulfilled, namely that the classification must be founded on an intelligible differentia which distinguishes persons or things that are grouped together from others left out of the group, and that differentia must have a rational relation to the object sought to be achieved by the statute in question. The classification may be founded on different bases, namely geographical or according to objects or occupations or the like. What is necessary is that there must be a nexus between the basis of classification and the object of the act under consideration. It is also well established by the decisions of this court that Article 14 condemns discrimination not only by a substantive law, but also by a law of procedure. No plausible explanation is forthcoming from the Union of India for the arbitrary or discriminatory conduct. There is no justification for distinguishing persons who are grouped together. The feeder cadre is PRO for all the three posts of IO, TIO, and DRC. Promotion is based on seniority. If three posts of DRC only are encadred, the juniors in the feeder as well as promoted category will steal a march over their seniors. That is with regard to the facts of the case. Not my submission is this. Not for the purpose of these 5 allowances, officers in scale 1 to scale 5 form members of a homogeneous class because of the object for which these allowances were introduced, not by reason of their holding ranks, but because not the policy says or not the revision order says by reason of the different ranks being held by the officers, the ceiling is revised from time to time. But the object for which these allowances had been introduced bring these officers under the same umbrella and they form as members of a homogeneous class. Now, differentiating amongst them for a different object or a wholly extraneous object is subclassification. And that's why the action is hit by Article 14.
We'll stop here. Have you
But
finished?
I conclude my submission.
Please submit on the next day.
Next table.
Yes. Mr. Mojumdar, comma. Now, notes of argument as handed over in court today on behalf of the petitioners. It's retained with the records. Mr. Mojumdar, comma, learned counsel, appearing on behalf of the petitioners. concludes his submissions. Stop. Mr. Sinha, comma, the next one, the learned counsel represents the State Bank of India within bracket SBI, bracket close, full stop. Let the matter appear for further hearing on. It will be very difficult for me to accommodate this side of the vacation. On June 9, 2020.
Kindly make it part hard since I don't know, but is it kept in the same position, my lord? Only an apprehension.
Only if he consents to June 9,
Yeah, part of how we
2023,
Part of that
under the same heading, court application.
He is not opposing.
Convince your learned friend.
I convinced him.
Ashu,
His position.
by consent
sir.
of the parties. This matter is now marked heard in part, since considerable judicial time has been expended in hearing of the same. তারপরে server court.
Next week, same position, madam.
Next week, I'll be very happy to keep it. If you want to come next Friday, I have no problem.
9th June.
Next,
Next week, ছুটি আছে।
next.
ছুটি ছিল।